May I have your lordship's kind leave, my lord, to mention item number 18. I'm led by Mr. Mitra, my lord. Item number 18 of today's list, commercial division. My lord, the section 11, this is a section 37 appeal. While, my lord, during the...
Yes, of course, we remember.
That section 9 was being heard.
Yes.
In the meantime, before the vacation, section 11 has been allowed arbitral tribunal constituted.
Right.
So I was wondering if you could request my lords for maybe for a shortcut, maybe interest of both sides.
So let this be listed on Monday under the heading.
My other side is also here.
Monday?
No difficulty.
For orders? Kaushik? Dita have na kichu? Monday for orders? At the top. Huh.
Lordship, may I be permitted to mention original side item number 65 and 66, my lord. These are those
non-commercial.
Non-commercial.
I'm opposing this, my lord.
These are those Lamartine school matters, my lord.
Well, I'm also opposing this. I'm appearing for 1 and 7 in this matter.
Lord, this matter was heard extensively by this bench, my lord, on 20th of June 2024.
What do you want? You want precedents?
Yes, my lord. If you were requesting if some precedents can be given, my lord, because it was heard and my lord has passed an order observing that there are some inconsistencies with the impugned order.
You tell us which matter is not important. We'll delete that matter from the list and we'll upgrade your matter.
Subject to your lordship's convenience.
No, you tell us. You help us. Next.
Oblige, my lords.
On your side, commercial matter. New application item number 1.
I appear for the respondent, my lord, on last
I
occasion.
appear for the appellant, my lord.
It's regarding whether, my lord, Order 7, Rule 10 is applicable to this, my lord, Honorable High Court. That I had said, my lord, there was an amendment of 1974 by which, my lord, that particular...
Yes, that notification number we have got also.
We have
found the notification.
itself. Notification item. May I hand over the notification? My lord, I have tagged the relevant portion. That by this notification and the court fees, my lord, on plain, this was, my lord, inserted. And along with that, my lord, that particular, my lord, clause was deleted from Order 49. Second last page. Thank you.
Is otherwise, what is the appeal about? We've forgotten.
In the appeal, my lord, what had happened, my lord, a non-commercial suit filed in a commercial division.
I see. So it was returned.
Yes, I filed an application, my lord, for return of the plaint for dismissal, but ultimately it was returned. Now,
is their only point that there is no provision to return the plaint?
What they now say is, while it is returned, the interim order and other, the suit should be treated as the same, only the number should be changed. But in case of a return of the plaint, he has to take the plaint back and file it again. So there is no suit pending. Correct. So there can be no interim or other orders, in respect of that. That is the limited question, that in the appellant had raised.
And only one thing, Section 4 of the Commercial Courts Act, it says, kindly say Section 4 of the Commercial Courts Act. In clause 1, in all high courts having ordinary original civil jurisdiction, the Chief Justice of High Court may by order constitute commercial division having one or more benches. So, my lord, it cannot be said that I have filed without jurisdiction. I have filed within jurisdiction. This is just a change of nomenclature. But in all the other high courts, this has been followed. And my lord, Order 7 Rule 10 is not applicable to the charter high courts. And it is.
That has now been deleted by this 74 notification.
Check that I have to come and check, my lord, whether this notification is still valid.
Hmm?
But thereafter, 1976 amendment also took place.
And 1976, what happened?
But that I have to check, my lord. I know that,
Check and come back on Monday. Both of you. We'll also check up.
yes.
Millard, there are two judgments, Millard, one by Justice Krishna Rao and one by Justice Arindam Mukherjee, Millard, which has recognized this Millard change. This in 1974 amendments. Also, I'm carrying those judgments if your lordship can kindly.
Where are those judgments?
Harshvardhan? What page number?
Doing
The paragraph 20 of this judgment, Millard. And Millard, paragraph 9 of paragraph 20 of the earlier judgment, reported in 2024 SCC Online Calcutta 10656 and the paragraph 9,
this one paragraph?
Harshvardhan Khemka paragraph 20.
And the other one?
The other one, paragraph 9, subparagraph Roman 4.
অন্যটা কোথায়?
This is at page 11. Copy. The internal page 11 of this judgment, Millard.
This 1997 2 CLT
Yes, I have found this.
is Justice Varin Ghosh by any chance? No.
But I was looking after it. I'm sorry.
Anyway.
Millard.
Oh, Ratni Devi Jain. Ah. ঠিক আছে। লেখো।
It's my turn, bro.
The copies of the judgments of learned single judges rendered in GA number 2829 of 2019, filed in CS number 216 of 2016, and the other one reported at 2024 SCC Online Cal 10656, we kept with the records. As a copies of the judgments filed by you. You are the respondent.
I'm the
Respondent. Paragraph, let this matter be listed once again next Friday, date under the same heading.
Monday I'll take 2 days. I am getting. I will do it.
No, not only for you, for everybody. Yeah, same thing.
Deep preparation.
TDO filter.
Fixed matter. Item number 20.
Yeah, well, let's continue. Well, first one, season's greetings to both my lords.
Asia's greetings. Yes.
What I was addressing, let's just try and Malad conclude my submissions. Today, Malad will remember Malad the award
Yes, yes.
challenged and
Yes,
Malad
remember.
the
58 crore, about 58 crore.
about 58 crore. Malad, the crux of the matter, Malad, which was argued by them, is really Malad on two issues. First, Malad was on the question that Malad whether the MGO clause, Malad will remember, stood waived or not by reason of that correspondence, which was really Malad their thrust before the first court. Here, Malad, they have argued mainly saying that evidence has been ignored. Therefore, we could not have suffered. We, Malad, the supplier of Malad, the CBM, could not have suffered any damages because Malad, there's a statement made Malad in the CRISIL saying that in March 2013, the demand was more than what Malad we were producing. That was really the crux of their Malad argument. And then Malad, of course, they also went Malad on mitigation. And Malad, to that, Malad, we recall Malad, I had argued and I was showing judgments Malad. First, Malad, just to have a 1 minute Malad recapitulation on Malad, whatever Malad I can try and Malad compress it as much as possible. First, Malad, on the question I said, Malad, that the law upholds validity of MGO clauses. That's Bihar state electricity and the Orissa state electricity, Malad, so far as our Supreme Court is concerned. I had also shown Malad from other jurisdiction, take or pay
To
clause.
protect the investment, basically.
Protect the investment. That's Malad, the logic, Malad, which they picked up Malad from 36 Calcutta judgment Malad of Justice Malad Mitter, Malad RC Mitter. So that's Malad the logic. And the tribunal has also found that MGO clause is valid. And this is Malad also supported Malad the findings of CCI as upheld Malad by the Delhi High Court in writ petition. And Malad will recall Malad in the award it is noted not once but twice saying that they do not dispute, that's paragraph 117 as well, they do not dispute the finding of the CCI or Delhi High Court. So that's Malad the second aspect Malad saying that the MGO clause is valid. The tribunal has also come to a finding that Malad the termination was wrongful. It is not in terms of the clauses in the gas supply agreement. And they have also considered the fact that this termination was brought about because they got, at that point of time, a less expensive supply from Malad SR Steel. That's Malad a clear finding. They had entered into an agreement Malad in April 2014 itself. And then they asked for waiver from us, and then Malad we said increase. That's the waiver of the MGO. We said increase the price. They said no, we will not. And then Malad that stopped. And then again they came and said no, we are agreeable to waiver. Then Malad they terminated. So Malad the tribunal has also come to that finding, including also Malad Delhi High Court when Malad they considered, saying that the reason was because you got that other supply, you really wanted to terminate, and you have terminated this illegally. Now Malad we had claimed this Malad agreement would have been till 2034 with the MGO clause. And the MGO clause, Malad will also recall, was calculated on the basis, Malad, that 26 days, 3 quarters.
Cycles or something.
That's right, correct. 3 cycles or quarters, Malad, and then it comes to Malad 78. So you have to take this minimum guaranteed offtake of Malad 78 days. Therefore, if you do not, then you have to pay. So we had calculated 2034. Malad, we had a substantial claim. The arbitrators then said, no, we'll give you only 15%. 15% of Malad the entire, relying on Malad 80 bridge wall, saying that we'll take that as a estimation of the damages which you would have suffered as a breach of contract. And Malad, that's Malad what we were given. Malad, I had relied on Malad, our judgments I have shown. There are Malad just 2 or 3 judgments which Malad I need to Malad just show on this aspect. Malad, only one thing, Malad, what had happened, Malad, we had relied on a compilation which was really Malad given Malad before the first court. At that time, Malad, we didn't have the division bench compilation ready. So Malad, we relied on that. Now, since Malad had already marked it, we did not take it away. We have done Malad a compilation 2 for Malad the Malad our division bench, Malad, which is Malad a compilation 2, but we have not included the previous judgment because I think Malad has already marked it. So Malad, that's the only Malad difficulty Malad we have insofar as Malad logistics is concerned. Malad, kindly come to उसमें सारे दिखा दिए हम लोग ने उसमें भी दिखा दिए Malad, this is only one অন্যটাতে না আরেকটা যে কম্পিলেশন আছে না ওটা একটু আপিল কোর্টের এটা লিখে কম্পিলেশন 1 করে দিন ওটা Season's greetings.
Same to you. What if you
আমি ফেরত ছিল তো চন্ডীগড় এসে পড়ছিল 5-6 দিন হলিডে তারপরে তাদের 18 তারিখ ছিল হ্যাঁ রবিতা কোর্ট খুলবে সোমবার না ওদের তো দিওয়ালি ছুটি ওদের দিওয়ালি 24-এর বদলে হ্যাঁ দিল্লিতে তো এরকম হ্যাঁ আগের গুলো ছিল আগে That we have already shown.
Yes.
But in this Malad, the first one, Somdat Malad, we have already shown. Para 45-46. Now, Malad, Punjab State Supplies Corporation, Malad, they have also relied upon that. Now, Malad, in this, kindly, Malad, have a look. Malad, division bench. Malad, kindly come to Malad, paragraph 16. Serial 3. আপনারা দেখেছি আমরা kindly look at Malad, paragraph 16 at page nahi hai kya? Page 28. Oh, मेरे को हमेशा why do you prejudice mine? It is seen that the scope of interference.
This year cited before or cited for the first?
Malad, my learned friend has
Go ahead, sir.
relied upon it. So, Malad, I put it. I'm also relying on it. Malad, I'm also relying on it. It is seen, paragraph 16. It is seen from the scope of interference in an appeal under Section 37 of the Act is restricted and subject to the same grounds on which an award can be challenged under Section 34 of the Act. In other words, powers under Section 37 vested in the Court of Appeal are not beyond scope of interference provided under Section 34 of the Act. Then 17, Malad, quotes MMTC. Then Malad, 18. Then Malad, recently a 3-judge bench. Then, sorry, so may I just read 18. Recently, a 3-judge bench in Konkan Railway Corporation Limited, Chenab Bridge Project under referred to MMTC Limited to held that the scope of jurisdiction under Section 34 and 37 of the Act is not like a normal appellate jurisdiction, and the courts should not interfere with the arbitral award lightly in a casual manner and cavalier manner. The mere possibility of an alternative view on facts or interpretation of the contract does not entitle the courts to reverse the findings of the arbitral tribunal. 19, Bombay Slum Development Corporation versus Samir bench, division bench of this court followed and reiterated principle later on case of MMTC Limited and usual power. It quoted and highlighted paragraph 16 of the later judgment, which extensively relies on MMTC Limited, reads as under. As it is the jurisdiction conferred on courts under Section 34 of the Arbitration Act is fairly narrow, when it comes to the scope of an appeal under Section 37 of the Arbitration Act, the jurisdiction of the appellate court in examining an order, setting aside or refusing to set as an order, is all the more circumscribed. In MTC Limited Vedanta, the reasons for vesting such a limited jurisdiction on the High Court in exercise of powers under Section 34 of the Arbitration Act have been explained in the following words. Then, Malad, as Section 34 is concerned, position is well settled by now that the court does not sit in appeal over the arbitral award, may interfere in merits on a limited ground provided under 34(2)(b)(2). Award is against public policy of India. As per the legal position clarified through decisions of this court prior to the amendment to the 1996 Act in 2015, a violation of Indian public policy in turn includes a violation of fundamental policy of Indian law, violation of the interest of India, conflict with justice and morality, and the existence of patent illegality in arbitral award. Additionally, concept fundamental policy of Indian law would cover compliance with statutes and judicial precedents, adopting a judicial approach, compliance with the principles of national justice, and when necessary, reasonableness. Furthermore, patent illegality itself has been held in to mean contravention of substantive law of India, contravention 1996 Act, and contravention terms of the contract. Then, my lord, conclusion, my lord, is in paragraph 20 and 21. I just, my lord, trouble, my lord, with that. In view of the above position in law on the subject, the scope of the intervention of the court in arbitral matters is virtually prohibited, if not absolutely barred. And 20, paragraph 20, sir. And that the interference is confined only to the extent envisaged under section 34 of the Act. Here, look. No, BBM, no. Punjab Herald. Punjab Civil. Sorry, my lord. Third line, the appellate power of section 37 of the Act is limited within the domain of section 34 of the Act. It is excisable only to find out if the court excising power under section 34 of the Act has acted within its limits as prescribed thereunder, or has exceeded or failed to exercise the power so conferred. The appellate court has no authority of law to consider the matter in dispute before the arbitral tribunal merits, so as to find out as to whether the decision of the arbitral tribunal is right or wrong upon reappraisal of evidence, as if it is sitting in an ordinary court of appeal. It is only where the court exercising power under section 34 has failed to exercise its jurisdiction vested in by section 34, or has travelled beyond its jurisdiction, that the appellate court can step in and set aside the order under section 34 of the Act. Its power is more akin to the superintendence, as is vested in civil courts, while exercising revisionary powers. The arbitral award is not liable to be interfered unless a case for interference is set out in the earlier part of the decision is made out. It cannot be disturbed only for the reason that instead of the view taken by the arbitral tribunal, the other view, which is also a possible view, is a better view according to the appellate court. It must also be remembered that proceedings under section 34 of the Act are summary in nature and are not like a full-fledged regular civil suit. Therefore, the scope of section 37 of the Act is much more summary in nature and not like an ordinary civil appeal. The award as such cannot be touched unless it is contrary to the substantive provision law and the provision of the Act or the terms of the agreement. Then 22, my lord. In the case at hand, arbitral award dated 8th November 2012 is based upon evidence and is reasonable. So, my lord, this is what is important: based upon evidence and is reasonable. It has not been found to be against public policy of India or the fundamental policy of Indian law, or in conflict with the most basic notions of morality and justice. It is not held to be against any substantive provision of law or the Act. Therefore, the award was rightly upheld by the court exercising powers under 34 of the Act. The appellate court as such could not have set aside the award without recording any finding that the award suffers from any illegality as contained in section 34 of the Act, or that the court had committed error in upholding the same. Merely for the reason that the view of the appellate court is a better view than the one taken by the arbitral tribunal is no ground to set aside the award. So, my lord, in fact, my lord, I remember, in fact, my lord's judgment is also that BBM. I'm sorry, I'll just refer to a few paragraphs of those. On the first day, my lord, had also, at least, my lord, the court was of the opinion that yes, we understand that even 37 is even narrower than in that sense 34, and we are not really examining the award all over again. We are examining whether the 34 judgment has taken care of the setting aside of the award claim in that sense.
Whether it has failed to exercise its jurisdiction or has exercised jurisdiction which it did not have. The thing is, for that we have to go through the award once.
Lord, one has to.
Lord,
though, Lord, it says, Lord, because I also, Lord, Lord, at that time when Lord, this fell, I know, Lord, quite naturally, Lord, has to look at the award to see whether section 34.
Correct.
But I would think, Lord, if section 34 court today says this is a plausible view,
correct.
Then, Lord, perhaps, Lord, then the division bench would say, sorry, I don't want to again go into that plausible view. So perhaps, my lord, that's the distinction, my lord, which can be, my lord, drawn, my lord, from this. Otherwise, of course, my lord, otherwise that's the main judgment, or my lord, the main, my lord, basis on which, my lord, we are considering. Now here, my lord, I see, my lord, award is mostly based on, my lord, a factual consideration as to whether the MGO clause survived or not. And the legal consideration, my lord, now the Supreme Court 2 judgments are there saying, yes, it's a valid clause. So the scope of interference, my lord, in that sense is very limited. Of course, my lord, can look at, my lord, the that when the damages have been awarded, whether that is according to some principle or not. There, my lord, of course, I rely upon my lord E.T. Brijpal saying that I've been given much less than what was claimed. And I also made a point, my lord, which I want to also, perhaps, hopefully, my lord, I made that good, saying that, my lord, today to come and say any evidence has been ignored is not the test. You have to come and say that this was such a vital evidence. If it was considered,
the award would have been different.
Award would have been different. Without that test, perhaps, my lord, one cannot get across and say that, because today court or, my lord, the arbitrators may consider something relevant, something not relevant. And I also pointed out, my lord, that paragraph in the award which considered their written notes of submission, where, my lord, they had mentioned the Chrysal Care report and had also mentioned that our returns before the ministry to, my lord, the ministry, my lord, that hydrocarbon, Director General of Hydrocarbon, shows that, my lord, there was some flaring up. So the award has picked up on that. And, my lords, will really have to consider, at least, my lord, that's the first court, that's what the first court did, saying that that's a plausible view. The award has gone on the basis that since there is admitted position that there's been some flaring up, the basis of damages are there. And that are also shown, my lord, that quotation which they repeatedly, my lord, rely upon, both, my lord, in the notes as well as in the evidence. It just, my lord, ignores that March 2013. Because March 2013 is not relevant. Termination happens, my lord, only in June in 2014. So what was the position there is no longer relevant to come and say that, my lord, I'm not entitled to damages. And, my lord, we had also shown that judgment, my lord, which we really liked, my lord, all of us, my lord, this side, that, my lord, Thompson, what's the car? Volkswagen. What is the car? My lord, where, my lord, if car is available, just because, my lord, that car is sold, doesn't mean more cars are not available.
Yes.
The Thompson, my lord, case, my lord, which we had relied upon. Right.
1955.
Absolutely, my lord. Absolutely. That's, my lord. Vanguard. So today, my lord, for them to succeed on this very tall claim, they will have to come and show, which they have not shown, either, my lord, before the arbitral tribunal or, my lord, anywhere, to say that there was no gas supply at all available. Because the logic being, my lord, if whatever is there, if I sell it to someone, doesn't mean I don't have more. I would have continued to supply you as well and make my profit. Which is the loss I have suffered. So, my lord, Punjab civil, my lord, I think, my lord, just, my lord, really lays down, my lord, whatever, my lord, the law is now, my lord, at present moment. Then, my lord, will kindly take, my lord, in that same, that BVM enterprise, my lord, this is my lord's judgment, the division bench judgment, my lord. I won't say it's no longer my lord's judgment, it's a division bench judgment, my lord. So, of, my lord, this honorable court. And here, my lord, will kindly look at paragraph 13 is, my lord, where the court's view is there. Page 39 of that compilation. We are concerned, sorry, my lord, has that, my lord, page 39. We are concerned with an appeal under section 37 of the Arbitration and Conciliation Act 1996. The appeal is directed against a judgment and order of a learned single judge of this court, allowing an application of the respondent state of West Bengal for setting aside an arbitral award passed in favor of the appellant herein under section 34 of the 1996 Act. What falls for our consideration of whether or not the learned trial judge acted within the parameters similar of Section 34 of the 1996 Act. It is established law by now that while exercising jurisdiction on 34 of the 1996 Act, court does not act as an appellate court. Learned court does not sit in appeal over the arbitral award. The learned judge has to see only if the petitioner assailing the award has been able to make out at least one of the grounds for sitting as an arbitral award, as mentioned, Section 34. Then, the section is set out, and then kindly come to paragraph 17 at page 41 at the bottom of that page. Under Section 2A, under Section 34, under subsection 2A, under Section 34 of the 1996 Act, domestic award may also be settled or is found to be vitiated by patent illegality appearing on face of the award. The proviso immediately clarifies only because the award has resulted from an erroneous application of law that will not be a ground for setting aside. The proviso further clarifies the award will not be set aside on the ground that there being patent illegality on the face of the award by reappreciation of evidence. We therefore see that the intention of the legislature was to reduce the role of the court to the minimum so that there is minimal interference with the arbitral process by taking recourse to court. Learned single judge has noted the decision of this court in the case of Lakshmipad Surana versus Wolters, the paragraph 7 of that judgment, discussing various judgments, and that is set out. This is another judgment of our courts. And then, I will request kindly come to paragraph 27 at page 45. It is too late in the day to dispute the proposition of law that the arbitrator is the ultimate master of the quantity and quality of evidence to be relied upon. Finding of an arbitrator on facts will rarely be interfered with by the courts. Similarly, insofar as the construction of the clauses of a contract is concerned, arbitrator's opinion will generally be accepted. Of course, if a finding of fact or an interpretation of a contractual clause is perverse on the face of the award, courts may justifiably interfere. In this connection, one may refer to the observation of the Supreme Court. Then kindly come to paragraph 29. In the present case, the arbitrator has taken a particular view as regards legality or otherwise of termination of the subject agreement. The view does not seem to be Wednesbury unreasonableness, unreasonable, or arbitrary, or preposterous, or perverse. Therefore, I find no justification for the learned trial court to have interfered with the finding of the arbitrator that the termination of the contract by the state government was illegal. As a reverse, the trial court has upheld this. Then kindly come to 31, and this is important. The arbitrator followed a formula accepted by the Honorable Supreme Court in the case of A.T. Brijpal Singh. Here also, the arbitrator had given that kind of on that basis. So, State of Gujarat, in paragraph 11 of the reported judgment, Honorable Court held as follows, now well established, then it's quoted in 32. Therefore, the percentage taken by the arbitrator at 15% cannot be said to be arbitrary or unreasonable. The question is 15% of what? It is 15% of the value of the unexecuted portion of the work. The tender value of the subject work was rupees 4,23. Although in the statement of claim, the claimant, that is BBM, has averred that it had executed work valued at rupees 2,24. In the counter statement of defense, the state of West Bengal contended value of the work executed by the claimant up to termination of the contract was rupees 26 lakhs. Therefore, going by the state's case, value of the unexecuted portion of the work as on the date of termination subject contract was 4,23 less rupees 26 lakhs, which comes to rupees 3,96. Arbitrator has awarded loss of profit to the tune of 15% of this amount, which comes to 59,51,032. Can it be said, 33, that the aforesaid approach of or procedure adopted by the arbitrator is perverse in law? I think not. The arbitrator followed a principle recognized by the Honorable Supreme Court. The arbitrator made the computation on the basis of the value of executed portion of work furnished by the state government. Was it unreasonable for the arbitrator to proceed on the basis of figures supplied by the state government? In my opinion, the answer must be in the negative. In this connection, one may refer to a 3-judge bench. The decision of the Honorable Supreme Court case of Srinivas Ramkumar versus Mahavat Prasad, 51 Supreme Court, and Malada's court, the court has quoted, my lord, from there. And then, my lord, kindly look at paragraph 36. In any event and independent of the formula governed by the Honorable Supreme Court case of A.T. Brijpal Singh, I am of the view that 15% formula adopted by the learned arbitrator for making an award on account of loss of profit is entirely reasonable. The arbitrator is an engineer and is deemed to have special knowledge. This is on the basis that they had deemed expert in field in connection with the dispute arose. Opinion should be brushed aside, should not be brushed aside lightly. Do not think that the award is made on account of loss of profit. 15% value of the unexecuted portion of subject contract so unreasonable that no reasonable person could have come to that conclusion, nor is the award such as would shock the conscience of the court. Well, Lord, here similarly, there was a question of unexecuted work. Here, my lord, is a question of, my lord, the unexecuted gas supply agreement, where, my lord, I would have got that. If the gas supply agreement would have been performed, which is, my lord, what a contract envisages, that to be put back in, my lord, the same position as if the contract has been performed. Unlike, my lord, the tortious principle, my lord, of. So, my lord, this, my lord, I am relying on this, my lord, quite naturally, my lord, to show that, my lord, two things. First, my lord, the scope, when, my lord, the courts will interfere. Here, my lord, the trial, the first court had set aside the award. My lords were pleased to, my lord, restore the award by, my lord, setting aside and saying, my lord, why an award, my lord, should be upheld, including, my lord, the calculation, my lord, of loss of profit at 15%, and which is exactly, my lord, what has been done, my lord, here. Now, my lord, one more, my lord, from this, kindly come to Sogali. My lord, item 4, Union of India versus Sogali Sugar Works. That's, my lord, at page 52. And just, my lord, this 4 lines, my lord, we thought, my lord, the principle, my lord, is paragraph 22 at page 56. The reported, my lord, we have already given 1976 3 SCC, page 32. And you see, the market rate is a presumptive test because it is the general intention of the law that in giving damages for breach of contract, the party complaining should, as far as it can be done by money, be placed in the same position as he would have been if the contract had been performed. The rule as to market price intend to secure only an indemnity from the to the purchaser. Market value is taken because it is presumed to be the true value of the goods to the purchaser. One of the principles of award of damages is that, as far as possible, he who has proved a breach of a bargain to supply what he has contracted to get is to be placed, as far as money can do it, in as good a situation as if the contract had been performed. The fundamental basis thus is compensation for the pecuniary loss, which naturally flows from the breach. Therefore, the principle is that, as far as possible, injured parties should be placed in as good a situation as if the contract had been performed. In other words, it is to provide compensation for pecuniary loss, which naturally flows from the breach. I could correctly apply this principle that adopted the contract price in the facts and circumstances case. So here also, my lord, the outer limit of giving me damages would have been, my lord, the entire period for 2034. That would have been outer limit, because that's, my lord, how the contract would have been performed. But, my lord, the arbitrators have thought fit, my lord, in their wisdom, that no, since we have a formula at least laid down by some of the Honorable Supreme Court cases, saying 15%, we will only give you 15%. So, my lord, nothing unreasonable. That would be, my lord, my submission. Then, my lord, kindly look at, my lord, item 5, my lord, Thompson, I have already, my lord, cited. That's, my lord, the 55. My lord, the citation there is 1955 to WLR 185.
Equal to 55 1
Yes.
AER.
55 1 AER 154. I'm grateful. 1955, sir. Volume 1, All England Reports, page 154. I'm not placing this, my lord. I'd already placed this, my lord, on the last occasion. Then, my lord, in this Gemini way, my lord, there is only one paragraph, my lord, which recognizes my lord, it starts, my lord, at page 66. My lord, will kindly come to, my lord, page 66. That's, my lord, where the judgment starts. My lord, I find my Justice Nariman's judgment, my lord, Rohington Nariman's judgment. Now, my lord, will kindly come to paragraph, my lord, 76 at page, my lord, 122. My lord, Lord, at page 122, Lord, will find, my lord, the final argument, para 76, final argument that the damages that have been awarded on no basis whatsoever would again not fall within any of the exceptions contained in section 48L. In order to address section 48.2, read with, Lord, this is of the Arbitration Act, my lord, for international, for 48.2, read with explanation 1.3, this court is Sangyong has held that it is only in exceptional cases which involve some basic infraction of justice which shocks the conscience of the court that such a plea can be entertained. This court held the expression most basic notions of justice find mentioned in explanation 1. Here again, what is referred substantially or procedure is some fundamental principle of justice which have been breached and which shocks the conscience of the court. However, when it comes to public policy of India argument, based upon this answer, then what 77. The arbitrator correctly held that as nothing was forthcoming from any of the appellants, he would have to make a best judgment assessment for damages. In making that assessment, took into account the commission that was being earned by GBT from the two clients of DMC and arrived at a figure of $100,000 per month, and then found on a reasonable estimate that they would continue to be clients for a period of 4 years, as a result of which the figure of $6,948,100 was reached. Then, Malad, kindly see how, Malad, what the learned, the Honorable Supreme Court relies on. That such guesstimates really, are not a stranger to the law of damages in the US and other common law traditional notions, has been established very early in a judgment of, let's see, relies again of, this is Ashutosh Mukherjee, reported as Frederick Thomas Kingsley versus Secretary of State for India. In this judgment, a learned division bench of the Calcutta High Court put it thus: it may be considered that though every breach of duty arising out of a contract gives rise to an action for damages without proof of actual damages, Mazet versus Williams says amount of damages recoverable is as general rule governed by the extent of the actual damage sustainable in the consequences of Defendants Act. In case admitting proof of such damages, the amount must be established with reasonable certainty, but this does not mean, it's not very important, that absolute certainty is required, nor in all cases is there a direct necessity for direct evidence as to the amount. Damages are not uncertain for the reason that the loss sustained is incapable of proof with the certainty of mathematical demonstration, or is to some extent contingent and incapable of precise measurement. As Justice Harlan observed in delivering the judgment of the Supreme Court of the United States in Hetzel versus Baltimore, certainly to reasonable extent is necessary. The meaning of the language is that loss of damage must be so far removed from speculation or doubt as to create in the minds of intelligent, reasonable men the belief that it is most likely to follow from the breach of the contract, and was a probable and direct result thereof. To the same extent is the decision Morris versus United States that where absolute certainty is impossible, judgment of fair men as to damages directly resulting governs. Then, Malad, this is what, Malad, Germany holds in 18.1 also. The facts in this case are far from removed from the facts in the aforesaid High Court judgment. No doubt whatsoever, result of the machinations of Upadhyay and Pathak found by the Arbitral Tribunal. ISS was deprived of commission legitimately due to it under the representation agreement. This being so, there can be no doubt
facts was proved before the arbitral tribunal, actual loss can be said to have been occasioned to ISS. In any case, the damages so awarded in the facts of this case cannot remotely be said to shock the conscience of this court so as to clutch at the basic notions of justice, ground content, section 48 explanation. So again, my lord, the court will really have to find that it is so shocking that when there is a breach of contract like this, my lord, a gas supply agreement, that this damages could not have arisen or could not have been assessed. That is, my lord, the test which, my lord, I respectfully submit, my lord, is, my lord, those are, my lord, our judgments. Now, my lord, will kindly come to my learned friend's judgment. Have you got chithi? Huh? আপনার চিঠির একটু পেজটা দেবেন, কারণ আমাদের নতুন এটাতে নেই আছে। Lord, if I'm not, my lord, mistaken, my lord, my learned friend, my lord, relied on, my lord, Bharat coking coal. That's, my lord, 2004-5 Supreme Court cases 109.
Yes.
My lord, paragraph 11.
ওদের কম্পাইলেশন ছিল না একটা, এটা নিয়ে না,
দেখে কম্পাইলেশন ছিল,
ওদের কি কম্পাইলেশন ছিল নাকি?
এটা বোধহয় আমাদের, দেখুন তো ভলিউম 1।
ওরা কি দেখিয়েছেন, লুজ আছে নাকি?
আই থিঙ্ক my lord, লুজ। আচ্ছা, এটা কিন্তু আমাদের করে লিখে ভলিউম 1 করে রাখুন। হ্যাঁ, 2 জজ সাহেবের ওটা 2 লেখা রয়েছে, এটা ভলিউম 1। सारा दिख रहा है paragraphs.
You started with Punjab State Supplies today.
I started, my lord, with
Punjab State
yes,
Supplies. No, we have just noted your preference for anything to do with Punjab these days.
my lord, it has to be naturally, my lord. I can't, my lord, help it. If I say, my lord, anything to the contrary, my lord, I shall be, my lord, in contempt of, my lord, both family law and, my lord, judicial, my lord. My lord, breach. পেয়েছেন? অনেকগুলো আছে কিন্তু বলে দেবো। 2015-3 আছে, ওগুলো বার করে নিতে ওইখানে। হ্যাঁ, ঠিক আছে, ঠিক আছে। My lord, this one, my lord, I don't think, my lord, there's any, my lord, dispute, my lord, with regard to the proposition in that sense. Kindly, my lord, come to paragraph 11. Bharat coking coal. At, my lord, internal page 114. There are limitations upon the scope of interference in awards passed by an arbitrator when the arbitrator has applied his mind to the pleadings and evidence, the evidence adduced before him and the terms of the contract. There's no scope for the courts to reappraise the matter as if this were an appeal, even if 2 views are possible. View taken by the arbitrator prevail. Award made by can said to be won by a reasonable person. No interference is called for. Cases when arbitrator exceeds the terms of the agreement or passes an award in absence of any evidence which is apparent on the face of the award, the same could be set aside. Now, my lord, with great respect, I submit, my lord, this no such case has been, my lord, made out, my lord, by my learned friend. To say, my lord, that either, my lord, the terms of the agreement has been exceeded or that in absence of any evidence. The award is not, my lord, without, with great respect, my lord, the award is well reasoned. The reasoning, my lord, may or may not appeal, my lord, to court or even to the division bench. But, my lord, that is no ground, my lord, to say that that is not a possible view. Because my lord has now seen all the evidence which is there. Their best cases, my lord, Care and Crisil. So on that basis, not possible. That's, my lord, our submission to say, no, the award now has to go. Then, sorry, you did not suffer any damages at all, though there was breach. So, my lord, they went on, my lord, paragraph 13, 15,
23 and 24.
Yes, 23 and 24. I'm grateful, my lord. Kindly come to my lord 23. Now, very important, my lord. This was a case. I'm very grateful, my lord. 23. Claim 8 has been rejected by the arbitrator. Now we proceed to consider claim 9 for loss arising out of turnover due to prolongation of work. The claim made under this head is in sum of 10 lakhs. The arbitrator rightly held that on account of escalation wages and price of materials, compensation was obtained. Therefore, there is not much justification in asking for compensation for loss of profit on account of prolongation of works. However, he came to the conclusion sum of 6 lakh would be appropriately compensation matter of this nature being 15% total profit with the amount that was agreed to. While a sum of 12 lakhs would be appropriate, he has held that sum of 6 lakh would be awarded in. Here, when claim for escalation of wage bills and price for materials compensation paid and compensation for delaying the payment of the amounts under the contract or for other expenses to be paid with interest thereon, it is rather difficult for us to accept the proposition that in addition, 15% of the total profit should be computed under the heading loss or profit. It is not unusual for the contract claim loss or profit arising out of diminution in turnover on account of delay in the matter of completion of the work. What we should establish in such a situation is that had he received the amount due under the contract, he could have utilized the same for other business in which he could have earned profit. Unless such plea is raised and established, claim for loss of profits could not have been granted. In this case, no such material is available on record. In the absence of any evidence, arbiter could not have awarded the same. This aspect was well. Now, my lord, two things, my lord, very important. First, this was considered, my lord, as a double recovery. And secondly, I am not saying that I am using this for the purpose of something else. Because what happened, my lord, in all these contracts, these claims are, my lord, all prolongation of work means your asset is being tied down to one project which is not being gainfully employed. To that, the court said this kind of damages, you will have to show that this you could employ somewhere else. And this is all the other judgments my learned friend has relied upon also, my lord, Unibros and all that, Butley are all on that principle. Whereas, my lord, both BBM and, my lord, the other one, Lakshmipat, my lord, that Surana, my lord, which was relied upon, my lord, in, my lord's, the division bench judgment, both are on the question of breach of contract, which a contract was to be performed. So the principles of awarding damages are quite different. One, my lord, is an executory contract, which you have admittedly now, at least on the findings, you have breached. So I'm entitled to a loss of profit. The other one is where I have incurred expenses by, my lord, being idle expenses, which just sits idle. Therefore, you have to also show that this could have been used somewhere else. So that's one of the principles. So, my lord, I most humbly submit that, my lord, Bharat Coking Coal, not, my lord, on the principle which, my lord, we are now, my lord, examining. Then, my lord, similarly, associated builders. This is 2015, 3 SCC. Page 49. I have noted, my lord, paragraphs 27 and 31. It application 2015 3 Supreme Court cases, page 49. I am told, my lord, paragraphs 18 also, my lord, was on the 27th. 18. 18 is on Renew, sir. 27. At page 73. (27 to 31). I think, my lord, straight away I should come, my lord, to 29 and 31. at page 75, it is clear, sorry, my lord, that the juristic principle of a judicial approach demands that the decision be fair, reasonable, and objective. On the obverse side, anything arbitrary and whimsical, which would obviously not be a determination which would either be fair, reasonable, or objective. Then, my lord, 30 is on the audi alterum partem principle. Then 31, third principle, juristic principle, that the decision which is perverse or so irrational that no reasonable person would have arrived at the same is important and requires some degree of expression. Settle that where a finding is based on no evidence, or an arbitral tribunal takes into account something irrelevant to the decision which it arrives at, or ignores vital evidence. This is when very important, or ignores vital evidence in arriving at the decision, such decision would necessarily be perverse. I have no quarrel with that, Malad. That's quite naturally, Malad, with great respect, yes. But I'm saying this is not vital evidence. In fact, your evidence has been taken into consideration while assessing damages. What you say in your notes, saying that there was flaring up. Your case was there was less flaring up. And you gave a chart, you also narrated. Because they wanted to come and say that, look, after termination, there has been less flaring up. Therefore, you did not suffer losses. Which the arbitrators have taken and saying, sorry, that's not good enough. As long as there is some flaring up, then we have to give them damages for the breach of contract. That's how the arbitrators. Now, if it's considered to be a plausible view, then the courts will not interfere. Quite naturally, if it's not considered a plausible view, then everything will go. It's a perverse decision, then according to all judgments. Then next, so what is the superior court? So now kindly come to Sangyong, which is 20. मेरे पास नहीं है. In our compilation, we have also relied on Sangyong. In fact, we have also relied on Sangyong. What the copy diya hai? It is there, also in volume 1 of our
Number 6, page 58.
serial number 6, page 58 of volume 1. I'm not. There are paragraphs, which really states the law. I have also relied upon. My learned friend has also relied upon. So, will kindly consider that. We have relied on paragraph 38, where it says no reappreciation of evidence. And my learned friend has also relied upon 36, 40, and 42. Same page. If comes to page, internal page 97 of that compilation. Is that correct? This paragraphs which you have given? 36, 40, and 42. Well, 30, I'm sorry, 36 has that. 36, I think what they have relied upon. I don't think anything different than. Thus, it is clear that policy of public policy of India is now constricted to mean, firstly, the domestic award is contrary to fundamental policy of Indian law, as understood in para 18 and 27 as builders, or secondly, that such award is against basic notions of it. Then, 37 and 38, we have relied upon it. Also made clear reappreciation of evidence, which is what an appellate will do, cannot be permitted on the ground of patent illegality, appearing in face of the award. Then 40 and 42. Again, patent illegality is explained. 41 also is thus finding based on no evidence in the middle. I'm so sorry, Placidum C. There's a finding based on no evidence at all, or an award which ignores, again, vital evidence in arriving at this decision would be perverse and liable to be set as on ground of patent illegality. Accordingly, a finding based on documents taken. Additionally, a finding based on documents taken behind the back. This one is not something which is not based on parties. So again, vital evidence. So I'm just adding a little bit to that vital evidence. I'm saying that has to be so vital would mean so important that it would have made a difference to the scheme of things. Otherwise, no, it is not vital. Then next is Punjab State Civil Supplies. I've just relied on that. That they had also relied upon. Then the next set, British Westinghouse. Very interesting. This is reported in 1911, 1 King's Bench. Pigeon. Losing.
I think they gave us 1912 appeal cases.
1912
appeal cases. King's Bench search trial could
7, 8 लिखी थी, भूल लिखते बड़ी नहीं.
Where is that?
देखो net.
No, King's Bench.
They responded.
It's 82-52. Now appeal Court of Appeal লেখা রয়েছে উপরে. হ্যাঁ, King's Bench Division 1912. 1912.
1912 appeal cases are decided করেছে. না, কেন? British Westinghouse.
कौन सा पैराग्राफ है?
Appeal cases. House of Lords.
House of Lords. Court of Appeal করছে.
না রে, 1912 appeal cases কত পাতাটা বলে দিন. আমি একটা কপি দেবো? আমাদের কপি দাও না একটা. আমাদের দিকে কপি নেই.
House of Lords. It is 90. Look, I'm so sorry, Malad. I don't seem to be having. May I just have a look at Malad, the House of Lords? Sorry, I'm just Malad. I'm so sorry. I'm just Malad.
আমি তো কপি দিইনি.
No, sir. আমি তো happily appeal court a judgment over. Anyway, I'm just Malad. Just take it out. Arey, take it out.
আমার কাছে রয়েছে.
Malad, I'll just skip over this judgment, Malad. I'll just take out a copy, Malad, and come back to this. Kindly, Malad, come to Paisu Sonda's litigation. It King's Bench Division.
19
Yes, no, 1919. Yes.
1992 King's Bench 581.
Mr. Mutro, in case Mr. Banerjee concludes today, will you conclude today?
Lord, I'll try and conclude. Lord, I have till 1:50.
Then will you start your reply today?
I can start. If
So
you
can
want.
we release your other friends till recess at least?
I think. I might not be.
Whether my learned friend will conclude.
There's a little doubt on that. Assuming he does.
If he does not, I can continue. I am ready with the reply.
Very good.
Accepting the judgments which has been cited today, I should be able to get rid.
All right.
Honorable matter really still recess, except this matter.
And I can tell you, Lordship, I shall confine myself to the judgment cited. I am not going to go into the facts.
জাজমেন্ট তো 1 মিনিট লাগবে।
বাইজু দিয়েছেন? এটা হলো 19
হ্যাঁ বাইজু।
Please take out the House of Lords bridge plate.
এগুলো আমাদেরকে বানিয়ে দিলে সুবিধা হতো জজ সাহেব। I should have given them in a
Compilation.
compilation.
Lord, Baizu was one of the case, very interesting, my lord. Lord, a defective machine was supplied, and they bought, my lord, a machine called Parsons machine, which were considered to be far superior than, my lord, even if the machine had been working, was supplied. So the claim was, my lord, for the purpose of defective, that you have supplied a defective machine, what is the damages which you're going to get? If my lord just looks at, my lord, the action, I'll just read, my lord. I don't think, my lord, there's any, my lord, in the head note itself. So, my lord, the head note, my lord, that question was there, my lord, whether the test we failed or not. That one head note which was wrong in
Yes.
All England report, which, my lord, haunted, my lord, all law students there. And, my lord, here, my lord, just Rajanath, I would say, no. Read the judgment. Head note is not, which is correct. Head note is not part of the judgment, really, my lord. But sometimes, my lord, it's convenient, my lord. Let's see the contract for the sale of goods by the defendant to the plaintiffs, provided the delivery should be as required during a period of 9 months. Oh, sorry, Parsons. That was British Western. I'm so sorry, my lord. I got confused. No, Parsons ta kothay chilo. I'm so sorry, my lord. That was British Westinghouse. I'm so sorry, my lord. Here, my lord, what happened? Oh, here this was different. I'm so sorry, my lord. Here, it was a question of, my lord. They supplied. There was a credit period. They failed. The defendant, then, my lord, they said, I will not supply if you don't give me the money upfront. And then, my lord, they were sued, saying that you are in breach of contract. And in that context, it was held that the offer given by them to supply it by paying cash money should have been accepted. That was what, my lord, mitigation was. If, my lord, I'm so sorry, I'm, my lord, confused with the other facts. British Westinghouse was at Parsons. Just find out. A contract for the sale of goods by the defendant to the plaintiffs provided that delivery should be as required during a period of 9 months, and that payment should be made for each installment within month of delivery, less 2.5% discount. The plaintiffs failed to make punctual payment for the first installment, and the defendant, in the erroneous belief that the plaintiff's failure to pay was due to their lack of means, refused to deliver any more of the goods under the contract, but offered to deliver the goods at the contract price if the plaintiff would agree to pay cash at the time of the orders. The plaintiffs did not accept this offer, and the market price of the goods having risen, brought an action against the defendants for breach of contracts, claiming as damages the difference between the market price and the contract price. And this is not what was held, my lord, by Justice McCarthy. If, my lord, comes to page 533, I don't know how, my lord, this principle, my lord, applies here. I'll just read, my lord, the judgment now. This is McCarthy. 583, sorry, my lord. Yes, 583. I'm sorry.
Yes.
Where, my lord, the judgment starts. Stating the facts, it has been contended on behalf of the defendant that the failure of the plaintiffs to pay on or about December 20 for the goods delivered in November constituted in circumstances such a breach of contract as amounted to a repudiation of the whole contract. Reliance was placed on Mercy Steel and Iron Company versus Naylor. It is not necessary to recapitulate the facts of the well-known case. In opinion, the decision, so far from being favourable of the present defendant, is distinctly against her. It is sufficient to render the following passage from Lord 7. Then, my lord, kindly come to page 585, now a serious question. Now, a serious question of law arises on the question of damages. I find as a fact that the defendant was ready and willing to supply the goods to the plaintiff at the times and prices specified in the contract, provided the plaintiff paid cash on delivery. Sorry, Madam.
Okay, yes.
585. Now, a serious question of law arises on the question of damages. Find as a fact that the defendant was ready and willing to supply the goods to the plaintiffs at the times and prices specified in the contract, provided the plaintiffs paid cash on delivery. Mr. Matthews argued with characteristic vigor and ability that the plaintiffs were entitled to ignore that offer on the grounds that a person who has repudiated a contract cannot place the other party to the contract under an obligation to diminish his loss by accepting a new offer made by the party in default. Then, my lord, the question is one of juristic importance. What is the rule of law as to duty to mitigate damages? Firstly, judge referred to the judgment of Justice Coban, Frost and Knight, where he said in assessing damages for breach of performance, a jury will of course take into account whatever the plaintiff has done or has had the means of doing, and as a prudent man ought to in reason have done, whereby his loss has been or would have been diminished. This rule is strikingly exemplified in Grace versus Calder, where the plaintiff claimed damages for wrongful dismissal, employed a manager of business carried by 4 persons partnership, forceful employment. That fact is disturbed. Then we can skip over that and kindly come to 586 in the middle, where Lord Holden is quoted. And after that, the question is, therefore, the question therefore is what a prudent person ought reasonably do in order to mitigate his loss arising from a breach of contract. I feel no inclination to allow in a mercantile dispute an unhappy indulgence in far-fetched resentment or an undue sensitiveness to slights or unfortunately worded letters. Business often gives rise to certain asperities, but I agree that the plaintiffs in deciding whether to accept the defendant's offer were fully entitled to consider terms in which the offer was made, its bona fides or otherwise its relation to their own business methods and financial position and all the circumstances of the case. It must be remembered that an acceptance of the offer would not preclude an action for damages for the actual loss sustained. Many illustrations might be given of the external results which would follow if the defendants were entitled to reject the defendant's offer and incur a substantial measure of loss, which would have been avoided by this acceptance of the offer. Plaintiffs were in fact in a position to pay cash for the goods, but instead of accepting the defendant's offer, which was made perfectly bona fide, plaintiffs permitted themselves to sustain a larger measure of damages, which as prudent and reasonable people they ought to avoid. But the fact that the plaintiffs have claimed damages on an erroneous principle does not preclude me from awarding to them such damages as they have in fact suffered, calculated upon the correct basis. See Cody and Thames. They have suffered serious and substantial business inconvenience, and I conceive that I am entitled to award the damages for that. Authorities are conveniently collected in unknown damages. Moreover, even if the plaintiff had accepted the defendant's offer, they would nevertheless have lost the very useful period of credit which the contract gave them. Taking into consideration all the circumstances of the case, I have come to the conclusion, right sum to award as damages £50. I give judgment for the plaintiff for the amount with important points. Well, with great respect, I don't know how this principle applies here. I have lost a bargain which was with you. Now, mitigation you have not argued what is the mitigation which I should have done, which I have not done, for which my damages would be reduced. In fact, anyway, my damages stand reduced to 15%. So, with great respect, Paizu, and in fact, in this case also, the judge said, sorry, I'm not going to, on that basis, I'm not going to ignore and not give them any damages at all. They still gave the plaintiff £50. So, two things, I say, the principle, which Paizu really talks about is that, yes, if the defendant considered it was a reasonable offer, you should have accepted it. That is the extent of mitigation. But here, there is no question of this principle being made applicable.
I relied on the appeal court judgment, which is afterwards. Which is after that.
Sorry, I seem to have...
Appeal court judgment is after that. Page 588, 589.
Kindly come to...
Yes, you cited both Lord Justice Banks and Lord Justice Crutton.
Yes, here also, kindly come to... Lord Justice Banks, starts at 587 after 587. 588. In these circumstances, I'm sorry, my lord, just before that, it is true that the correspondence, my lord, at the beginning of 588, it is true that the correspondence suggests that the respondent was at one time claiming an increased price. But in this quote, it must be taken that the offer was to supply the contract goods at the contract price, except that the payment was to be by cash instead of being on credit. So here, my lord, the only correspondence was with regard to, my lord, whether the MGO clause stands waived or not. And that's not the argument which they're running like, my lord, Paizo and Saunders. Now, my lord, next, in these circumstances, the only question is whether the appellants can establish that as a matter of law, they were not bound to consider any offer made by the respondent because of the attitude she had taken up. Upon this point, Justice Curdy referred to British Westinghouse, where Lord Holden, fundamental basis, thus compensation for pecuniaries naturally flowing from the breach. But this first principle is qualified with second, which imposes on a plaintiff duty of taking all reasonable steps to mitigate the loss consequent on the breach and debars him from claiming any part of the damages which is due to his neglect to take such steps. I'm grateful, my lord. I'm also relying on this principle because I have to show that. In the words of Lord Justice James Duncombe Colliery, what the plaintiffs are entitled to is the full amount of damages which they have really sustained by breach of the contract. Person who has broken the contract, not being exposed to additional cost by reason of the plaintiffs not being done, not doing what they ought to have done as reasonable men, and the plaintiffs not being under any obligation to do anything otherwise than in the ordinary course of business. It is plain that the question what is reasonable for a person to do in mitigation of his damages cannot be a question of law, but must be one of fact in the circumstance of each particular case. There may be cases where, as a matter of fact, it would be unreasonable to expect a plaintiff to consider any offer made in view of the treatment he has received from the defendant. If he had been rendering personal service and been dismissed after being accused in presence of others of being a thief, and after that his employer offered to take him back services, most persons would think he was justified in refusing the offer, and that it would be unreasonable to ask him in this way to mitigate the damage in action of wrongful dismissal. But that is not to state a principle of law, but a conclusion of fact to be arrived at on a consideration of all the circumstances of the case. Mr. Matthews complained that the respondents treated his client so badly that it would be unreasonable to expect them to listen to any proposition she might make. I do not agree. In my view, each party was ready to accuse the other of conduct unworthy of a high commercial reputation. Nothing to justify appellants in refusing to consider respondent offer. I think the learned judge came to a proper conclusion on facts, and the appeal must be dismissed. So the trial, Justice McCarty's judgment, my lord, stands, and also, my lord, Lord Justice Cratton, I am of the same opinion. And this Eve also says, my lord, I agree. So, with great respect, my lord, I do not understand, my lord, how this principle applies to our case. What is the factual assertion which my learned friend made before the arbitrator? Or what is the factual case which my learned friend's client ran to say, my lord, what is the mitigation of option available to me? You have to show what I have not done. Because his argument on, my lord, that entire correspondence with regard to MGO clause being waived is one separate chapter. It's nothing to do with mitigation. His case was MGO clause stood waived, which, my lord, both the learned arbitrators and, my lord, the Delhi CCI and well as the Delhi High Court held that no, sorry, it was not waived. So that's the case he ran. And so far as, my lord, the other case is concerned, he ran the case that no, you have not suffered damages because your flaring up reduced. So I do not see, my lord, how this question of mitigation is applicable to us, so as to reduce my damages. Today, my lord, if it's a factual assertion, it has to be, my lord, made there. So that's why, my lord, I was a little surprised, my lord, why Paizo and Saunders relied upon. What is that he accuses me of? That what is that I have not mitigated? The facts are there. It is correct. According to the facts, in the arbitrator also held that it has gone down, flaring up. It says that's nothing. That doesn't mean that you have not suffered damages. And, my lord, I've been given damages. Then, my lord, kindly look at other judgment, my lord. This
Any other surprises you have for me? My Lord Lachia Sethi. This is my Lord 1984 Supreme Court cases 636. Please get a copy. You're giving me the division appeal court bhi nahi di wo. That I'm just I don't know why. 1984 SSC. Lachia Sethi. Whether Krishna is going to differ from the first House of Lords is the same.
Then 4 SCC 636. 1980 volume 4 তুমি 1984 দিলে
1980 volume 4. Okay. So kindly come to. Sorry. Well, this is on the principle of mitigation, and kindly will not come to paragraph 13. At page 644. The last contention urged by counsel for the appellants on the quantum of loss claimed by the respondent comprised a two-pronged attack against the resale held in respect of the defaulted lots of coffee. First, the board was under an obligation to mitigate or minimize the loss arising from the failure on the part of the appellants to pay for and take delivery of the coffee allotted to them at the pool auction. But instead, deliberate measures were taken by the board to bring down the price of coffee, and it then effected a resale on December 23, 1952, resulting in the alleged loss of rupees 34,000 such and such and 5 which could not be regarded as a loss directly and naturally arising from the breach in the ordinary course of events, but was unreal, created and brought about by the respondent, and therefore the same was not recoverable from the appellants. Secondly, the resale was not held within reasonable time of breach, but was inordinately delayed, and therefore the appellants were not liable for the quantum claimed. May be stated that the contention that the defaulted coffee ought to have been put up for sale at export auction and not at pool auction, though urged in the lower courts, was not pressed before us for the reason which will indicate presently, do not find substance in either of these two grounds. Then 14, the principles are given now. At the outset, it must be observed that the principle of mitigation of loss does not give any right to the party who is in breach of the contract, but it is a concept that has to be borne in mind by the court while awarding damages. The correct statement of law in this behalf is to be found in Halsbury's Laws of England. Plaintiff's duty to mitigate loss. The plaintiff must take all reasonable steps to mitigate the loss which he has sustained consequent upon the defendant's wrong, and if he fails to do so, he cannot claim damages for any such loss which he ought reasonably to have avoided. Again, in para 1194 and 478, the following statement occurs under the heading standard of conduct required of the plaintiff. Plaintiff is only required to act reasonably, and whether he has done so is a question of fact in the circumstance of each particular case, and not a question of law. How, with great respect, my lord, doesn't arise before the appellate court from in a section 37 to come and say, no, sorry, you also look at this, there's no mitigation of damages. He must not act not only in his own interest, but also in the interest of defendant, and keep down the damages so far as it is reasonable and proper by acting reasonably in the matter. In case of breach of contract, the plaintiff is under no obligation to do anything
can you see in cases of breach of contract, the plaintiff is under no obligation to do anything other than in the ordinary course of business. And where he has been placed in a position of embarrassment, the measures which he may have been driven to adopt in order to extricate himself ought not to be weighed in nice scales at the instance of the defendant, whose breach of contract has occasioned the difficulty. Plaintiff is under no obligation to destroy his own property or to injure himself or his commercial reputation to reduce the damages payable by the defendant. Furthermore, the plaintiff did not take steps which would injure innocent person. And then in Banco de Portugal, quoted Sansaj, in England, the law is that a person is not obliged to minimize damage on behalf of another who has broken a contract. If by doing so, he would have injured his commercial reputation by getting a bad name trade. American jurisprudence contains the following statement. Then, my lord, kindly after my lord, that statement, sorry, my lord, may I just read this? I'm so sorry, my lord. Thus, the damages awarded, this page 646, to the non-defaulting party to a contract will be determined and measured as though the party had made reasonable efforts to avoid the losses resulting from the default. Some courts have stated this doctrine in terms of a duty owing by the innocent party to the one in default. That is that the person who is seeking damages for breach of contract duty to minimize those damages. However, on analysis, it is clear that in contract cases, as well as generally, there is no duty to minimize damages because no one has a right of action against the non-defaulting party if it does not reasonably avoid certain consequences arising from the default. Such a failure does not make the non-defaulting party liable to suit. It only indicates that the damages actually suffered are greater than the law will compensate. Therefore, in contract actions, the doctrine of avoidable consequences is only a statement about how damages will be measured. From the above statement of law, it will appear clear that the non-defaulting party is not expected to take steps which would injure innocent persons. If so, then steps taken by performance or discharge of his statutory duty can also be weighed against it. Substance, the question in each case would be one of reasonableness of action taken by a non-defaulting party. Then 15, here the materials on record clearly show that the internal coffee price in the year 1952, particularly from March to October 1952, had soared very high on account of malpractices indulged in by coffee dealers. And even the government of India felt itself very much concerned about it and suggestions had been made by government officials as well as members of the coffee board to take steps to bring down the coffee price at reasonable level in interest of both the trade as well as the consumer. In fact, several measures, including the step of accepting lower bids in preference to higher bids with a view to regulate coffee prices, were taken by the coffee board pursuant to the government's directive in the bill. Clearly, these measures were being taken by the board in discharge of the main function, duty to maintain the coffee price proper level in the interest of all concerned, particularly consumer, not but directed against the defaulting dealers at the concerned production facts. So this is a lot on the fact. Because what had happened, Malad, they bid, they failed to pay. Price was very high. Then, Malad, the coffee board sold off at a lower price. So they came back and said, no, you could have sold it at a higher price. And the lower price, because of Malad, the government circular saying that please regulate coffee price, don't let it go so high. But what I'm on, Malad, that mitigation is purely a factual issue, which has to be argued, Malad, before the first court with evidence. Today, Malad, no case, Malad, of mitigation, Malad, that what we have failed to do was made out, Malad, before the arbitral tribunal, Malad, factually. Now, Malad, kindly come to Malad. Now, Kailash Nath, 24, that's Malad, the next judgment, 2015, 4 SCC 136. Malad, in Kailash Nath, Malad will recall, Malad, it related to I think, Malad, EMD which was forfeited, either EMD or Malad. So, EMD being forfeited, there the courts held that you have to show that what damages you have suffered before you can get this. Because, Malad, the next e-auction, Malad, was at a higher price. Malad, that principle doesn't again, Malad, apply here. So kindly look at, Malad, the
Kailash Nath. And sometimes, my lord, with great respect, my lord, I think, my lord, we ourselves, my lord, get a little carried away, my lord, with Kailash Nath. My lord, paragraph 2. Oh, sorry. Thank you, sir. চিঠি অন কন্ট্রাক্ট পেজটা আমরা পাচ্ছি না
প্লাস্টিক ফোল্ডারটা কোথায় গেল? আপনাদের সঙ্গে কেসগুলো ছিল, রানও নেই।
সফট কপি আছে চিঠি
চিঠি অন কন্ট্রাক্ট কোথায়? বার করে দেখ।
আমাদের জানি না, আমাদেরটা দিয়েছিলেন যদি হারিয়ে গেছে বা দেননি আমি জানি না বেশ।
দিয়েছিলাম, তুমি জেনে নেবে।
Yes.
My lord, in Kailash Nath, my lord, will kindly come to my lord, paragraph 2. Why? What the fuck? My lord, paragraph 2, I'm sorry, my lord. Appeal, a present appeal arises out of a public auction conducted by the Delhi Development Authority, wherein the appellant made the highest bid for plot number Sunsets for rupees 3.12 crore. As per terms of the condition of the auction, appellant being the highest bidder deposits sum of rupees 78 lakhs, 25% of bid amount with DDA. This being earnest money under the terms of the conditions of auction. Relevant provisions in the conditions of auction read as follows. The highest bidder shall at the fall of hammer pay to the Delhi Development officer conducting the action 25% of the bid amount as earnest money either in cash or by bank draft for Delhi Development Authority or check guaranteed by scheduled bank as good payment for 3 months in favor of the Delhi. If the earnest money is not paid, the auction held in respect cancelled. Then, my lord, kindly come to at paragraph 6 there. At page 142. Where when the bid is accepted, DDA, the intending purchaser shall be informed that such acceptance writing and intended purchase shall be in 3 months thereof pay to the Delhi Development Authority balance 75% amount of the bid in cash or bank draft in favor of Delhi Development or by check granted by a scheduled bank as good for payment for 3 months in favor of Delhi. If the bid is not accepted, the earnest money will be refunded to the intending purchaser without interest unless the earnest money is forfeited under para 2.4. And 2.4, my lord, says in case of default, breach or non-compliance of any of the terms and conditions of auction or misrepresented by the bidder and intermediate, the earnest money shall be forfeited. Sorry.
Yes.
My lord, paragraph 29, my lord, then my lord, 154, page 154. Based on the facts of this case, it would be arbitrary for DDA to forfeit the earnest money on 2 fundamental grounds. First, there is no breach of contract on the part of the appellant, as has been held above. And secondly, DDA not having been put to any loss, even if DDA could insist on a contractual stipulation in its favor, it would be arbitrary to allow DDA as a public authority to appropriate 78 lakhs without any loss being caused. It is clear, therefore, Article 14 would apply in this field of contract. In this case, finding of division bench on this aspect is hereby reversed. Then, my lord, kindly come to paragraph 33. The section 73, my lord, is 74 is set out. Then kindly come to
34 is my lord Fateh Chand. Discussed. Then 35 Mola box. Then my lord kindly come to 40 at page 161. From the above, it is clear that this court held that Mola box, sorry, my lord, page 161, my lord, paragraph 40. From the above, it is clear that this court held that Mola box case was not on facts a case that related to earnest money. Consequently, observation Mola box forfeiture of earnest money under a contract if reasonable does not fall within section 74 and would fall within section 74 only if earnest money is considered a penalty is not on a matter that directly arose from decision in that case. Law laid down by a bench of 5 judges in Fateh Chand is that all stipulations naming amounts to be paid in case of breach would be covered by section 74. Because section 74 cuts across the rules of English common law by enacting a uniform principle that would apply to all amounts to be paid in case of breach, whether they are in nature of penalty or otherwise, must not be forgotten that what has been, as has been stated above, forfeiture of earnest money on the facts in Fateh Chand case was considered. In the circumstance, it would therefore be correct to say that as earnest money is an amount to be paid in case of breach of contract and named in the contract such, it would necessarily be covered by section 74. Must, however, be pointed out case where a public auction is held, forfeiture of earnest money may take place even before an agreement is reached, as DDA is to accept the bid only after the earnest money is paid. Present case under the terms and conditions of auction, highest bid along with earnest money has to be paid may well have been rejected. In such case, section 70 may not be attractive. Then, my lord, 42, in the present case, forfeiture of earnest money took place long after an agreement had been reached. It is obvious that the amount sought to be forfeited in the facts of the present case sought to be forfeited without any loss being shown. In fact, it has been shown that far from suffering any loss, TD has received a much higher amount on re-auction of the same plot of the land. And that is how, my lord, on 43, then, my lord, on a conspectus of the above authorities, the law on compensation for breach of contract 74 can be stated as follows. When a sum is named in a contract liquid, then, my lord, reasonable compensation, all that. So, my lord, here, my lord, with great respect, my lord, I submit that, my lord, this is not a case where it's a question of forfeiture. Contract having been performed, I would have got that money. It's the expectation. Yes, my lord, I'll continue and, my lord, try and, my lord, I think I'll finish. I'm sorry, I would have, my lord, finished, but another, my lord, 15 minutes or 20 minutes, my lord, at most. Or
It's an hour.
half an hour. Half an hour at most. Half an hour at most. That's all I'm saying. চিঠি on contract কি judgment to show that আমরা নতুনটা carry করছি my lord I'm sorry my lord the চিঠি on contract my lord maybe just have a copy of that because we don't seem to be having that
I shall give my copy if I have it.
আমরা স্যার এখান থেকে কোর্ট থেকে দেখে নেব আমরা পরের the next edition my lord we don't have that my lord earlier
ওইটা এডিশন তাহলে আমি একটা কপি পাই
হ্যাঁ সেটা তো স্যার দিয়ে দিতে
All right, then 2 o'clock.
To buy it, I don't. Therefore, I would welcome a copy.
I don't think my lord that statement my lord should not even be.
Are you telling that? Are you saying that I'm making a false statement?
I wish I can be like. No, that's why I'm not saying anything. It is understood by all and the court.
Mr. Sinha is supporting Mr. Banerjee.
No, Mr. Sinha is clever. Yes, right.
Oh, sorry. Oh, gotcha.
Judgment, I can know one.
Suspense. No, Mr. Lahiri.
Lord, I have one request to make for your lordships. Lord, when the appeal was admitted, 1st May 2024, we were directed to, Lord, they were to, we had furnished bank guarantees and we withdrew the monies that they had deposited. Those bank guarantees are lying with the registrar.
I see. You had furnished the bank.
Yes, there are two bank guarantees which are both mentioned in this order. We had furnished bank guarantees and withdrawn the money that they had deposited. Your lordships, kindly take page 2.
Lord will not allow them to withdraw the bank guarantee because we have a.
Yeah, nothing remains
No,
now.
we have to go to the.
There is no list pending anywhere.
But till we go to the. Because we have to renew the order of stay there.
Mr. Lahiri, since we have said there's nothing in the appeal, no merit, and they had been, or they furnished the bank guarantee in terms of an order passed in this appeal, and since we are dismissing the appeal, logically we have to allow them to withdraw the.
Because if we go,
Otherwise,
if
they
we
may
go,
file, they may not file, speculative.
Whether you will go or not, we know the conduct. Go, so what?
for 4 weeks, my lord, let them not. After 4 weeks, they can, my lord. But we have a chance to go to the.
You
for
go,
4
who's stopping you from
but
going?
for 4 weeks, my lord, if my lord, the bank guarantees cannot be
No.
taken back. 4 weeks is not make, my lord, any.
No, there's no reason why my money should be stuck now. There's no list pending anywhere.
In that case, we'll have to stay the operation of this judgment,
Okay.
which we are not inclined to do. Which we are not inclined to
But
do.
I understand for 4 weeks. we
Esho,
get the
are you
bank
praying for stay of this judgment? Esho. Later. After judgment is delivered in open court, learned advocate for the appellant prays for stay of operation of the judgment and order. Stop. Such prayer is considered and refused. Paragraph. At this point, learned senior counsel for the respondent draws our attention to an order dated
orders হবে না দুটো অর্ডার
না একটা অর্ডারই দুটো আছে
না পরে একটা 60 লাখ 60 কোটি টাকা দিয়েছে
এর মধ্যেই আছে দিয়েছে তো third paragraph is one bank guarantee and
AP was filed by you.
yes.
AP.
That was for the returning, getting the money.
For getting the money against the bank guarantee,
I see.
which is permitted. And your lordship will find third paragraph.
You have no appeal.
No.
Before us. First, which paragraph? Sorry.
Third paragraph, your lordship will find at page 2, third paragraph. That's one bank guarantee. And there's another bank guarantee in the second last paragraph of 60 crore for the additional amount. 2 crore 50 and
draws to our attention and order dated May 1, 2024. Passed
250 crores.
50 crore in the third paragraph.
By a coordinate bench at the time of admission of the appeal. Stop.
Page 2, Lord, third paragraph.
One is third paragraph and then?
And then, Lord, second last paragraph, 60 crore.
Same page.
That was the additional amount during the pendency of the matter and before the trial court.
Because this
Lord, therefore, an additional amount was directed to be furnished. 60
That
crore.
also you have withdrawn.
That also we have withdrawn against
that two bank guarantees which were lying of 310 crores odd.
250 crore plus 60 crore.
Stop. He says that in terms of that order, the monies deposited by the appellants before the
Registrar.
Registrar, Registrar General, Registrar, original site, of this court, were withdrawn by the respondent upon furnishing two bank guarantees of approximately rupees 250 crore.
The amounts are here, not please give the
Oh,
exact amounts.
for rupees 2,50.
The first comma is irrelevant.
Irrelevant, you're right. Rupees 250, comma nahi, 250, comma 32, comma 41, comma 670.49 and rupees 60 crore. Stop. Since the present appeal stands dismissed, comma, the bank guarantees should be returned to the respondent. Paragraph. Learned advocate for the appellants opposes such prayer. Stop. Paragraph. Since we have dismissed the appeal as being meritless, comma, we see no reason for directing the respondent to continue to furnish the bank guarantees. Stop. The learned registrar, comma, original site, comma, is directed to forthwith return the bank guarantees.
Maybe give the bank guarantee numbers to your lordship's officer and
bearing numbers blank and blank to the respondent at the earliest and definitely within a fortnight from date.
Very pleased. Very pleased.
That makes it 3 weeks so that I have a breathing.
Said forthwith.
And I understand.
Within 3 weeks from date.
So that,
Within 3 weeks from date.
so that I have some breathing space.
Within 3 weeks from date. Very well. এটা নাও রেখে দাও রেকর্ডস দেরি করে আসবো
Entire vacation.
সরি
Devoted the vacation for this judgment.
চলো
Very
শোনো শোনো
I
8 and
Malad, I apologize, Malad. This respect items 3 to 5, Lordship. Mr. Roy Chaudhary is on the other side. I'm led by Mr. Mukherjee and Mr. Banerjee. Malad, that is Mr. Mukherjee is on the way. He's not reached Calcutta yet, Malad. I was only making a prayer if it could be taken up on the 3rd, on Monday.
third. Very well. On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on ওই ডেটটা যেটা বললো, comma, retaining its position.
Grateful.
Same order in all three matters.
3rd November.
3rd November. 3, 4, 5.
3, 4, 5. Grateful, Malad. I apologize, Lordship.
Continuing matter, item number 2. Lord, I was just finishing off Lord Kailash Nath.
Yes.
With Lord paragraph 42, last paragraph read. And with my Lord submission,
Kailash Nath.
That Kailash Nath Lord was not a case which lays down any principle on the question of assessment of damages for breach of a contract in this, like Mullah, what we are considering. It was a case saying that when it's a forfeiture, then you can't have a windfall gain. You must show some damages to get your forfeiture amount or whatever the amount is. So that principle, Mullah, again, I have no dispute because that principle is not applicable here.
Not a breach of contract.
Not a breach of contract. Not a breach. What we are considering is Mullah, a breach of an executory contract, which if performed, I would have got Mullah, all that money Mullah, as a minimum guaranteed offtake. And which is Mullah, really the determination. That's Mullah Kailash Nath. Then Mullah, after that, Mullah Butley Boy. That's Mullah 2024, 2 Supreme Court cases 375 in the judgment. Butley Boy and Mullah Unibros.
Look at the
2024 2 SSC 374. Your judge. Punch down the
Yes.
Again, Malot sees paragraphs 2 and 3 at Malot page 384. What was Malot the nature of damages Malot which was claimed? On acceptance of tender and in terms of the letter of intent dated 27/2/1992, HPCL had awarded to BL the turnkey contract for detailed engineering, including civil, structural, design, supply, and erection, testing and commissioning of 23 MLT storage capacity sewage water reclamation plant in Maholsand. Contract value was rupees 574.35 lakhs. Contract period was 18 months from the date of letter of intent, and accordingly, the work was to be completed by 28/8. There was delay in completion. On written request application made by BELL, the time for completion was extended on 2 occasions. 3 revisions were also issued by HPCL. The last revision dated 20th September 1994 had extended the period of completion from 26/9 by 10 months beginning from the date on which approval of electrical items was accorded to by HPCL. BL carried on the work till 30th 3/1996. Thereafter, BL abandoned the work. It is an accepted position that as on 30th March, 80% of work was complete. On 4/7/1996, paragraph 3, BL made a formal complaint to HPCL for breach of contract on account of delay in execution, causing extra expenses and losses. By the letter dated 16/5/1997, BL sought an advance payment of 50 lakhs to enable them to resume work. Simultaneously expressed desire to resolve the dispute through conciliation. By the said letter also invoked the arbitration clause contract. Proposal as given by BL was unacceptable. Letter refused to make payment, relying on the terms of the contract and impressed upon BL to resume and complete remaining work, even if matter was to proceed to arbitration. BL did not agree and resume work. So, this was one of the factual background, and then let's see paragraph 5. Compensation for loss of overhead and profit, and also profitability. Then at page 386, we will find at Placid Terminal E, 10% of contract was given. And then claim 2, compensation for idle machinery and equipment, rupees 84 lakh 59,615. And here Malachi's claim is for machinery and equipment deployed in the execution of this contract had to idle for a large part of the time due to extended contract period. I have inspected the site. No opinion there is substance to the claim. After due all this, award an amount was 50 per month for a period 20, which comes to rupees 12 lakh. So how the award was. And compensation for losses incurred due to increased cost of materials, claim 3, then claim 4. Then this is the award which was given. Then kindly come to paragraph 14. At page 390, in McDermott International Court has referred to various methods of computation of damage in para 102 to 107. Particular reference has been made to Hudson's formula, eminence on Ickley's formula, H-Ley's formula in the following terms. Then methods for computation of damages. Then 14. Then kindly come to all these formulas are discussed. Then paragraph 16 at page 394. There is without doubt a sound, legal and correct proposition. 394. However, the computation of damages should also not be whimsical and absurd, resulting in a windfall and bounty for one party, expense of the other. Computation of damages should not be disingenuous. Damages should commensurate with the loss sustained in a claim for loss on account of delay in work. In a claim for loss on account of delay in work attributable to the employer, the contractor is entitled to loss sustained by the breach of contract to the extent and so far as money can compensate. The party should be placed in the same position with the damages as if the contract had been performed. Principal sum of money awarded to the party who has suffered the injury should be the same quantum as she would have earned or made if she had not sustained the wrong for which she is getting compensated. Then we subsequently categorize. Then paragraph 38, I am told, 38 was 38. So 16, I find, there's nothing, which is, in fact, reiterates the same principle. Then paragraph 38 at page 405. Page 405, 38, again, general proposition, 39. 40, 41. At page 407, at the top, further, what would constitute public policy matter given nature of pleadings of the party? Tacitum A and B. Pleadings of the party and material brought before the court would be relevant to enable the court to judge what is public good or what is in public good or public interest. So, what would otherwise be injurious to public good and interest? Relevant point. This is public policy, particular government. Well, I don't think, any of these principles, are, to disagree with or, and what is, important here. And 47, just may also show paragraph 47, page 410. We have extensively analyzed the award, its patent flaws and illegalities which emanate from it, like the manifest lack of reasoning in arriving at the conclusion and the calculation of amounts awarded, which in fact amounting to double or part double payments. Besides being contradictory, etc., in view of the aforesaid reasoning, award has been rightly held to be unsustainable, set aside division in High Court, and power and excellence. Well, this doesn't, with great respect, the basis of this matter where, it was a question of delayed damages, because delayed damages, has a totally different principle of awarding damages. It's if you've incurred, then only it's a question of, but here I'm not on the question. I'm saying if the contract had been performed, then this is the total gain I would have got from that award. And I've got 15% of that. Now the court, I'm sorry, I'm really now repeating myself, whether that's reasonable or not. So, I don't think, Butley Boy furthers their case. Then, Unibros, that's 2023. SCC Online SC 1366. That's the copy I have. Unibros collector. Okay. Here also, paragraph 3, will find. So 3 So we'll kindly take paragraph 3. We'll find here also it's a case of delay damages. Relevant facts discerned from records reveal that the appellant was awarded a work contract by the respondent to carry out construction Delhi Doordarshan Bhavan. Phase 2, New Delhi. Work was scheduled, commenced on 12th April 1990, reached completion 11th April 1991. However, it suffered a delay of roughly 42.5 months, finally completed on 30th October 1994. Dispute and differences emerged between the parties owing to such delay, which were subsequently referred to an arbitrator for resolution. And the trajectory of the case, all that is there. And then sees escalation and all that were claimed. And kindly take paragraph 13, which was relied upon. Having read the second award, we have no hesitation to hold that it fares no better than the first award, for it is equally in conflict with the public policy of India. Notice from the order dated 20th May 2002 of the learned single judge that while remitting claim number 12 for reconsideration, arbitrator was warned not to be influenced by the factors that weighed in his mind while making the first award. Arbitrator was also required to proceed only on the basis of the evidence on record. Yet, regrettably, what we find is that the arbitrator went on to ignore judicial decision of High Court with impunity. He once again emphasized on delay caused by the respondent in completion of works entrusted to the appellant by not providing complete site and drawings within the stipulated contract period, and that non-handing over of sites certainly constituted fundamental breach of contract, which in entire contract. Referred to Hudson's espousal of fundamental breach of contract, which according to him was the standard text in all engineering building contract. Therefore, apparent factors which weighed in the arbitrator's mind, the first round, second round, one and the same. The word in charge of being branded mirror image of the first award. Second, arbitrator appears to express in language from different. So that all this is not relevant. Then 14, it is elementary, though it has to be restated. The judicial decision of Superior Court, which is binding on inferior court has to be accepted with grace by the inferior court, notwithstanding decision of superior court may be palatable to the inferior court. Principles answer. Arbitrator and multi-member tribunal as well, particularly was faced with a judicial decision 3437 ordering a limited remand to wake of authority of judicial determination made by the court of law and award of an arbitrary tribunal seeks to overreach a binding decision. Then, my lord, I have great respect, my lord. I don't think, my lord, that is. Then, my lord, 15, my lord, Bharat Coking Coal, my lord, is referred. Then, my lord, kindly look at 16. To support a claim for loss of profit arising from a delayed contract or missed opportunities from other available contracts that the appellant could have earned elsewhere by taking up any, it becomes imperative for the claimant to substantiate the presence of a viable opportunity through compelling evidence. This evidence should convincingly demonstrate that had the contract been executed promptly, contractor would have secured supplementary profits utilizing its existing resources elsewhere. This is, I have absolutely no grievance with this. No, I'm not joining issue. But that is not the case here. This is on the principle that if the contract is delayed, if your resources are lying there, it's idle. You'll also have to show that if this was used somewhere else, it would earn profit. Here, my lord, I'm complaining of a breach of contract. I already have a contract with you. I have a contract with you. If you perform the contract up to 2034, I would have got all this profit. Or the minimum, forget the profit, the minimum guaranteed output. Which is what I've lost. And my lord, kindly remember, my lord, in both Bihar and Orissa, the Supreme Court supported even, my lord, after disconnection, and that's exactly the principle. After disconnection of electricity by the electricity board, they still allowed, my lord, the minimum guaranteed amount to be paid. Then, my lord, then 1718, my lord, is on the question of Hudson's formula. My lord, 18. Again, my lord, kindly see 18, the last 4 lines. While this formula are helpful, last 5 lines. When needed, they alone cannot prove the contract loss or profit. They're useful in assessing losses, but only if the contractor has shown with evidence the loss of profit and opportunities it suffered owing to the prolongation. And then, my lord, 19, law as it should stand thus is that for claims related to loss of profit, profitability opportunities to succeed, one would be required to establish the following conditions. First, there was a delay in the completion of the contract. Secondly, such delay is not attributable to the claimant. Thirdly, the claimant's status as an established contractor handling substantial projects. And fourth, credible evidence to substantial claim of loss of profitability. Perusal of the record will satisfy fourth condition, namely, evidence to substantiate the claim for loss of profitability remains unfulfilled in the present case. And here I have a confirmed contract with you. So, my lord, both my lord, Unibros and my lord, Butley Boy and Kailashnath, the principle, my lord, on which they talk about assessment or measure of damages, my lord, is totally different than, my lord, what we have here. And that is recognized, my lord, by all as well, saying that if the contract had been performed. Even, my lord, that's why I showed, my lord, Butley Boy also made that. Now, my lord, kindly come to, my lord, their other, my lord, I want to first show, my lord, Chitty, and then, my lord, I'll come to British Westinghouse, which doesn't, my lord, say with great respect, my lord, on the mitigation aspect, nothing, my lord, new. Kindly, my lord, look at Chitty, which my learned friend relied upon. This is, my lord, the 25th edition. My lord, and it's the same, my lord, which is, my lord, there also, my lord, in the last edition, the 32nd edition, my lord, the portion, my lord, which I want to rely on. You have the 33rd. I also have the 32nd. Lord, kindly look at 800. My lord, my learned friend, my lord, relied upon 1714 and 1715. But I think, my lord, the law is laid down, my lord, in that judgment of, my lord, Justice Tulsapurkar, so far as India is concerned, my lord, on mitigation. So we really don't need to, but I'm also, my lord, showing this. There are three rules often referred to under the comprehensive heading of mitigation. Considered in turn, firstly, the plaintiff cannot recover for loss consequent to defendant's breach of contract, where the plaintiff could have avoided loss by taking reasonable steps. Secondly, if the plaintiff in fact avoids or mitigates the loss consequent to defendant's breach, he cannot recover for such avoided loss, even though steps he took were much more than what could be reasonably required of him under the first rule. Thirdly, where the plaintiff incurs loss or expense by taking reasonable steps to mitigate the loss resulting from defendant's breach, plaintiff may recover his further loss or expenses from the defendant. Convert avoidable loss. First rule impose on a plaintiff duty to take of taking all reasonable steps to mitigate the loss conduct consequent breach and debars him from claiming any part of which is due to his neglect to take such steps. Position of the plaintiff under this rule is similar to that of a plaintiff whose damages are reduced because of this contributory negligence. Onus of proof, now I'm not tiny c. Onus of proof is on the defendant, who must show that the plaintiff ought, as a reasonable man, to have taken certain steps to mitigate his loss. Any loss which is directly caused by a failure to fulfill his duty is not recovered from the defendant, Thus, an employee who has been wrongfully dismissed and all that one is gone. Then, my lord, kindly turn over and kindly come to at 1717. This, my lord, was not read, my lord, by my learned friend. Now I want to, my lord, rely on this.
It was read.
Sorry, my lord, once and that, my lord, is also very. I'm grateful to my learned friend. I'm sorry, my lord, I said that. Now, my lord, kindly look at 1717. In contract for the sale of goods, the normal rule for the measure of damages assumes that the innocent party would act immediately upon the breach and buy or sell in the market if there were an available market. Where the plaintiff does not accept the defendant's anticipated breach of contract, there is no duty on the plaintiff to mitigate his loss before the actual breach on the due date for performance. Now, my lord, this is very important. Another instance of mitigation arises where the defendant in breach of the contract refuses to accept the goods which he has agreed to buy, but the plaintiff is able to sell the goods at the same price to a third person if the state, this is very important, if the state of the market is such that demand exceeds supply, so that the plaintiff could always find a purchaser for every article he could get from the manufacturer. He is entitled only to nominal damages from the defendant, not his loss of profit on the repudiated sales, since he sold the same number of articles and made the same number of fixed profits, or he would have done if the defendant had duly performed his contract. So, my lord, for him, it is not, my lord, my duty. It is, my lord, and it, again, my lord, not his right. So, he will have to come and show. And as it says, all my goods were exhausted. That's one of the Thompson case. And which, in fact, my lord, considers British Westinghouse. My lord, I also show British Westinghouse. So, if I had, my lord, again going back to the, if I had, my lord, 10 cars to sell, 9 cars were already sold. He was to buy the 10th car. He fails. I sell the 10th car, which is the only cars available with me, to someone else at a profit. I'm not entitled to any damages. And that is for really for him to show as a factual matter, not, my lord, come up, my lord, and argue, my lord, before the appellate court,
that this is where it's not a question of mitigation. Let's not, my lord, also, it's not a question, it's a question of going into the measure of damages, which is, my lord, a factual issue. Because I think, with again, my lord, with great respect and humility, I say, my lord, let's not, my lord, mitigation and measure of damages, my lord. Mitigation is a part of measure of damages. But doesn't mean, my lord, the measure of damages, his case is that I have not suffered any loss at all. Mitigation only reduces to that extent, which is not a case, my lord, which is run on mitigation. His argument is, no, you're not going to get any loss because your flaring up has reduced. That is where, my lord, I'm saying, my lord, sorry, with great respect, my lord, that principle, my lord, is not applicable, my lord, so far as we are concerned. And now, my lord, kindly look at British Westinghouse. My lord, kindly look at British Westinghouse. My lord, that House of Lords. This is, my lord, the facts which I was narrating. What had happened, my lord? The
1912 AC.
1912, my lord, appeal cases. My lord, here, my lord, the railway company had entered into a contract, my lord, with the Westinghouse to buy certain machineries. Here, my lord, there were electric machines, the turbo alternators. The machinery which was supplied was, my lord, defective. They used that after, my lord, the period of, my lord, expiry of their natural life. They, my lord, then changed it with very superior machines of higher quality of the Parsons machine. Now, the Parsons, as a matter of evidence, was considered to be superior. And the evidence was also that even if Westinghouse machines performed to their maximum capacity, Parsons were much better and would have taken care of all losses. So in the first place, they should have really gone for Parsons. So the principle is, my lord, that if I have made a bad bargain, that bad bargain cannot be compensated by later making a good bargain and claiming the price from them. So here, where is that question? I only have one contract with you. So, my lord, in that case, and what had happened, my lord, the arbitrators had stated this, my lord, to court. That's what, my lord, the first King's Bench division and, my lord, the appellate court had put those questions, saying whether it is a relevant fact that Parsons was a superior machine and working of Parsons would have given greater profit. Was that a relevant fact? The first court, my lord, King's Bench said that no, it is not a relevant fact. Don't take into consideration. Appellate court said that, affirmed, my lord, the single bench. Then, my lord, the arbitrator passed the award on that basis. Then it was challenged again. And, my lord, the House of Lords, my lord, set aside all that, said no, it was only a question stated. That principle is not correct. Please go back to the arbitrator to now assess the damages. That is, my lord, the context in, my lord, which this was delivered. Now, my lord, kindly, my lord, take with me, my lord, at paragraph page 588, sorry, 6. No, 588. 583.
You have got appeal cases.
Oh, sorry, again I'm. Where's the House of Lords? Oh no, it's here. अभी तो पढ़े
वो the King's Bench देखছে
but again मतलब this sometimes नहीं this technology sometimes मतलब goes contrary.
Come back to
Not using it. It's a 688, sorry. Oh, ऊपर में. Now, kindly come to this is the 1912. Now, kindly come to page 688. I'm sorry, Malad. Just before that, I want to trouble my lord at 684. This is Malad, the finding, which is Malad, very important. Sorry, Malad. 684. Malad will find in the middle. He found further that the purchase, Malad has that. He found further that the purchase of the Parsons machines was to the pecuniary advantage of the respondents, and that the superiority of Parsons machines in efficiency and economy over those supplied by the appellant was so great that even if the appellants had delivered to the respondents machines in all respects complying with the conditions of the said contract, it would yet have been to the pecuniary advantage of the respondents at their own cost to have replaced the machines supplied to the respondents by Parsons machine as soon as the letter could be obtained. This is a finding. Then, Muller, having found these facts, he set out the contention of the parties. Case of the appellants was in substance that on the facts as stated, he was entitled to draw the inference that the commercial life of these machines had expired at the date of the purchase by the respondents of Parsons machines, and that these facts were therefore relevant to the question of the amount of damages recoverable on the counterclaim, and that accordingly no further damage of any kind were recoverable by the respondents after the date which they could procure Parsons machines, and further that the cost of procuring and installing Parsons machines were not recoverable by the respondents. Contention of the respondent, on the other hand, was that the cost of the purchase and installation of the Parsons machines was recovered by them from the appellants as being the necessary cost and expense incurred by the respondents in mitigating as from the respective dates when a Parsons machine was substituted for each of the appellants' machines, damage which they would have been entitled to recover from the appellants. The arbitrator then stated under the powers conferred by the Arbitration Act 1889, two questions of law for the opinion of the court. First was whether the contention of the appellants as above was set out was well founded, and the second was whether it was not so. If that was not so, respondents were right in their contention. Cost to them of the purchase and installation of the Parsons machines was recoverable by them from the appellants as part of their damages. This is Mullah the background, and this is Mullah the principle of law. Then Mullah will kindly come to 680. I'm not Mullah taking Mullah to the conflicting opinion or Mullah the Court of Appeal or Mullah the. So Mullah, they were very good judges. I found Mullah Lord Justice Buckley, Lord Justice Vaughan Williams. Then Mullah 688. The arbitrator appears to me to have found clearly. It has that Mullah, the second paragraph on that in the middle. The arbitrator appears to me to have found clearly that the effect of the superiority of the Parsons machines and of the efficiency in reducing working expenses was in point of fact such that all loss was extinguished, and that actually the respondents made a profit by the course they took. So, Mullah, this is a finding. They were doubtless not bound to purchase machines of a greater kilowatt power than those originally contracted for, but they in fact took the wise course in the circumstance of doing so with pecuniary advantage to themselves. They had moreover used the appellant's machines for several years and had recovered compensation for the loss incurred by reason of these machines, not being during these years up to the standard required by the contract. After that period, the arbitrator found that it was reasonable and prudent to take the course they actually did in purchasing the more powerful machines. All the remaining loss and damages was thereby wiped out. In order to come to a conclusion on the question as to damages thus raised, it is essential to bear in mind certain propositions which I think are well established. In some of the cases, there are expressions as to the principles governing the measure of general damages, which at first sight seem difficult to harmonize. The apparent discrepancies are, however, mainly due to the varying nature of the particular question submitted for decision. Then what sees quantum of damages is a question of fact. Now, let me also come into now question of arbitration award, whether at all courts would go into this question of fact or not. and the only guidance the law can give is to lay down general principles which afford at times but scanty assistance in dealing with particular cases. Judges who give guidance to juries in this case remains necessary to look at their special character and to mold for the purpose of different kinds of claim, expression of the general principles which apply to them and that is apt to give rise to an appearance of ambiguity. Then, subject to this observation, think there are certain broad principles which are quite well settled. First is that as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed, as far as money can do it, in as good a situation as if the contract had been performed. The fundamental basis is thus compensation for pecuniary loss, naturally flowing from the breach. But this first principle is qualified by a second, which imposes on a plaintiff the duty of taking all reasonable steps to mitigate the loss consequent on the breach and debars him from claiming any part of the damage which is due to his neglect to take such steps. In the words of Lord Justice James in Duncombe Coley, the person who has broken the contract is not to be exposed to additional cost by reason of the plaintiffs not doing what they ought to have done as reasonable men, and the plaintiffs not being under an obligation to do anything otherwise than in the ordinary course of business. Then, as Lord Justice James indicates, second principle does not impose on plaintiff obligation, and it's a reasonable prudent could not only. Then, we will kindly come to paragraph page 690. I think that in the middle, the paragraph again. I think that this decision illustrates a principle which has been recognized in other cases, that provided the course taken to protect himself by the plaintiff with such an action was one within which a reasonable and prudent man might in the ordinary conduct of business properly have taken, and in fact did take, whether bound or not, a jury or an arbitrator may properly look at the whole of the facts and ascertain the result in estimating the quantum of damages. Well, with great respect, my lord, British Westinghouse also doesn't say anything, my lord, to the contrary. It's on the question of mitigation, and it says you have to take reasonable steps. Now, he will have to come and say that what is that mitigating step I have not taken? Because this case has really not been on mitigation. His case is that you have not suffered damages because your flaring up has gone down. So, my lord, these are, my lord, I think, my lord, his judgments, my lord, which have been relied upon. Now, my lord, if I'm sorry, my lord, I'll just take, my lord, just 5 more minutes, my lord, or 10 minutes, my lord, on the impugned order itself. And sorry, my lord, just before I finish this, my lord, will recall the Chrysler and the care, the only evidence which he shows and which the arbitrators really, my lord, did not go into in detail was, my lord, that statement of 2013. March 2013. My lord has already made a note of it. My lord, I'll just just, my lord, give me, my lord, 221. No, 221. No. My lord, 2212. I'll read out, my lord. Will recall, my lord, that portion, my lord, which was it says, my lord, as of March 2013. This is page 2212. As of, well, I'd shown this. Well, as of March 2013, the company had aggregate commitments to purchase up to 412 million metric standard cubic meter MMSCM of CBM as against 85 in production in FY 2013 as per draft red herring prospectus. And the termination, my lord, was in June 2014. So how is this, my lord, evidence so vital as to, my lord, change the entire face of the award, which you're in breach of, my lord? I'm sorry, with great respect, that is, my lord, not evidence, my lord, which is forthcoming. Because you will have to show that I had no supply anymore, no gas supply anymore. Now, my lord, now quickly, my lord, coming back to, my lord, the impugned order, which is, my lord, 5th September 2024. Okay. That is, my lord, page 6P, memo of appeal. My lord, in the memo of appeal,
the internal pages.
Yes, my lord, I'll refer to the internal pages. I marked it. I've just made this. My lord, kindly come to my lord, paragraph 49. Paragraph 41. What is 41? The notes refer.
Yes, Mr. Bench.
I'm sorry, my lord. Just my lord, kindly look at my lord, paragraph 36 at internal page 12. Also not part of our submission. Which starts, my lord, from paragraph 29, my lord, it starts, and kindly come to what 40, my lord, can take, my lord. Next, dealing with the argument of SRMB, page 13, finding of the tribunal on the quantum of damages based on no evidence and or in ignorance of vital evidence, learned such for the claimant argues tribunal unequivocally held that the agreement is valid subsequent April 30, 2034. SRMB had breached the agreement and wrongfully terminated the same. Considering the nature of the contract, tribunal refused to grant specific performance, but observed that the claimant still has a right to recover compensation in the form of damages for the loss or benefit it would receive had the agreement survived, continue full term until April 30th. Then 41, contention of SRMB that no loss or damages suffered by the respondent due to such illegal termination has been wrong. Tribunal relied on the 42 on the factual finding of the CCI dated February 11, which was affirmed by the Delhi High Court by its order dated October 10. Effect the claimant had to flare up 28.48% of gas produced in 2015-16 as a no market for the same after SRMB terminated contract July 2014. Learned counsel for the respondent argues that admittedly post-termination agreement, claimant had to flare up gas. Contention that the gas being supplied earlier to us and sold to others was also contended before Delhi High Court, turned down in paragraph 53 of the said judgment. Very fact that this is a very important argument, the very fact that the gas had to be flared up, ipso facto means that there was no buyer for the same and the claimant supplied gas to SRMB. Such gas would not have been flared up, thus flaring of gas itself the proof of losses. Then, my lord, kindly come to 44, my lord, it records recovered capital investment and cost, my lord, that is our argument. And 49, my lord, is the finding. At page 16, 50, my lord, 49 it starts, and 50, my lord, will see the plinth of the case of SRMB. There was a concluded contract between the parties on waiver of the MGO clause upon consequent increase of the purchase price ₹5 per SCM. This is, my lord, what they had really argued before, my lord, the first court. Now they have, I don't think, my lord, they have argued, my lord, so strongly here.
So my lord, that takes from 50 up to my lord 63, 64, 65. 66 my lord is where my lord the first court my lord holds. On the analysis of my lord what the arbitrators have held, that hence the finding of the tribunal in regard are perfectly justified. My lord, they have also not my lord really pressed for that. Then my lord kindly come to 67 is interpreted the correspondence particular manner. This is very important. 67 also importantly, the tribunal interpreted the correspondence in a particular manner which is perfectly plausible in law and on the facts of the case. Proviso to section 34(2)(a) of the 1996 Act clearly precludes the court from coming to the conclusion of patent illegality by reappreciation of evidence. Even if the court there were a different opinion, the tribunal on the issue of waiver of MTO clauses, the court ought not to come to the conclusion that there was patent illegality by substituting its own view, that of the tribunal. So this is not again the court's view saying that it's a plausible view, the first court. Then 68 says no, okay, inference. Then 69. Next question falls for consideration whether termination contract was unlawful. Termination admittedly divorced 4 contracts, relevant provision for termination. Then my lord, termination is my lord also considered and held to be my lord 79 my lord will see. Hence the award to the extent that the termination was bad is also justified, since the non-renewal of bank guarantee to SRMB was entirely unilateral, divorced the contract and contrary to law. So that's my lord paragraph 79. Then my lord 80, which is what really has been argued here. Where is mitigation argued? What argued about? Well, at least, my lord, I do not find, my lord, subject to correction, my lord, that mitigation was argued, because I do not remember, my lord, either before, my lord, the arbitrators, my lord, definitely, my lord, not, I don't think this was argued, but anyway, just check, my lord, subject to correction. Then 80. Last component of argument to SRME petition is that there was no evidence of loss to justify the award of damages. However, the tribunal categorically relied on the order passed by the CCI, conclusion of which was ultimately affirmed on merit by the Delhi High Court, wherein it was observed the claimant had to flare up 28.48% of the gas produced in 2015-16, that is after the illegal termination of the agreement. Delhi High Court, somewhat different context, held that it was nobody's case that gas could not be supplied to other consumers. In such backdrop, it was observed that not the case of SRME, that if the customers are availing requiring gas at a particular point of time, gas available to the claimant would not be supplied to them. MGO liability was held was only to mitigate the risk in committing to a long-term supply, and that the fact that the quantity of gas which was earlier supplied was after termination contract being supplied to other purchasers does not in any manner render clause 5.2 of the agreement unfair discriminatory. Hence, it was not a conclusive finding, nor was the court so called upon to discern merits of the issue as to whether the gas earlier supplied to SRMB was being supplied to others. Premise of paragraph 53 of the Delhi High Court judgment was merely that it was nobody's case that gas could not be supplied to others. Even if there was such supply only after termination contract, it does not render clause 5.2 unfair discriminatory. Said observation cannot be blown out but has to be read in context. Rather, categorical finding of the CCI order, which was affirmed by the Delhi High Court, that 28 point was flared up. Then my lord 84. Even otherwise, if we proceed on the basis of the CRISIL report and the CARE report, as well as the documents filed by SRMB, which if assumed to go on to show that there was almost equivalent flare up of gas even after termination contract as there was before the same, does not help SRMB in any manner. Premise of the MTO clause is not an actual occasion of loss suffered by the supplier. It is a prevalent practice in such long-term contracts for supply of energy by way of electricity, gas, etc., to introduce a minimum consumption clause, which is in the nature of an assurance to the supplier that the huge investment in grid and other infrastructure for supply to consumers, which is undertaken by such supply is justified by long-term supply. Premature termination would only entail loss of the minimum guaranteed amount, which is the MGO value in the present case, but also may be detrimental to the maintenance supply grid itself. Also, it is irrelevant whether the same amount of gas is consumed before by SRMB was flared up, even after termination of the contract with SRMB. As long as there was even a small amount of flare up, it would indicate that at least some of the gas produced by the supplier is not used up. It is not a relevant question whether the gas earmarked for the consumer SRMB was being supplied to some other consumer, since supply to one consumer is not mutually exclusive with supply to some other. Now, chitty on contract saying the demand has to exceed supply. I always have the gas. I have lost out on a bargain with you. Apart from supplying you, I would have supplied to several other customers. But you cannot, I cannot supply. That contract is gone for me. Additional profits I would have made. And that's exactly what the learned judge reasons. It may very well be that the supplier enhances its infrastructure and or on the basis of the same infrastructure caters to more consumers, thereby increasing its earnings. Even if SRMB was continued to be supplied with gas, it was open for the claimant supplier to increase its supply and or to maintain its previous supply and go on supplying gas from its network grid to other new consumers, which would fetch more profits to the supplier. There was no exclusivity clause in the agreement between the parties restricting supply only to SRMB. Hence, even if the claimant went on supplying to others over another quantity supplied, it would have earned more profit, to which there is no bar. Thus, as long as there is even a wee bit of flare-up gases, there is a wastage of gas produced by supplier. Consequently, there cannot be dilution MGO clause suffered by the supplier. Therefore, after the termination, supplier might have started supply to new customers. Even then, as long as the entire amount of produced gas, this is not very important. Even then, as the entire amount of the produce not exhausted, supply would continue to suffer loss due to termination of the contract for the particular amount of gas which will be supplied to SRMB. It is not the gas earmarked for SRMB is being supplied to others. Claimant the producer gas can very well supply. Hence, the argument of SRMB linking the quantum of post-termination flare-up gas to absence of loss is irrational, not acceptable. Even if the flare-up remained the same, the supplier suffers loss to the extent of the MGO amount as long as there is flare-up of any amount. And such argument specious but not acceptable. Then, my lord, on this 90 concept of MGO in any event is provide certainty. All that, my lord, is considered. Then 91. Hence, in a comprehensive perusal impugned what unable to find infirmity or illegality in the same. Argument is present, does not guide. Then, my lord, judgments, my lord, discussed and my lord. So, my lord, so therefore, my lord, two things now. First, my lord, will consider the award and see, my lord, whether, my lord, it is based on no evidence. And whether, my lord, any finding, my lord, is so perverse that, my lord, the court has to interfere. Then, my lord, will also consider the fact that first court at least has found that it's a plausibility. So only in the case, my lord, the division bench finds that both are really not plausible, then, my lord, the award goes. Otherwise, my lord, it has to, my lord, survive. And, my lord, mitigation I did not find, but, my lord, that's my learned friend's argument. 19. My lord, Mr. Mukherjee tells me, my lord, paragraph. Oh, argue according, I'm quite sure. Yes. 19 and 20 of the judgment. Later, Krishna has only argued for our bull. Sorry, my lord, just give me one, my lord, 30 seconds. No, mitigation a point as such. Right. I have 19 is the highest. You don't have to there is no loss or damages. Sorry, my lord, I'm so sorry. Right. Well, just kindly look at my lord, paragraphs 19 and 20. I don't know, my lord, whether this is a mitigation argument. At page 7 of my lord, the judgment.
But it seems, my lord, as I said, my lord, the main argument saying that you have not suffered any losses. This is their argument.
It's perhaps not mitigation.
That's, my lord, what I thought. Sort of. I understand their argument, saying that but for that you have to really establish I had no goods to supply. Because I've come and said that you breached a contract. I'm sorry, I've lost out on the contract.
It is in a sense a step towards mitigation. If you see it.
Correct.
Well, those are, my lord, our submissions. My lord, I'm extremely grateful, my lord. I'm sorry, my lord, if I had delayed, my lord, the court more than, my lord, what I should have, my lord. I'm grateful.
You have about 15 minutes today.
But in fact, I was ready to start immediately, but there had been some amount of, what should I say, persuasion from my juniors. They don't start it today, sit with us. Well, the problem is this. During the holidays, I had plenty of time to study. They are busy, my lord. They could not.
That we understand. Very well. When will you argue? Tell us.
Any day, my lord.
At the commercial next Monday.
Yes, Monday.
Sure. Monday.
Very well, right.
देखो. Oh.
Something is fixed.
Today is Friday, so Monday is all right for you?
Monday is all right for me.
Mr. Rottanku Banerjee, Kamalan Senior Counsel, representing the respondent, concludes his argument. Paragraph. As requested by Mr. Mitro, Kamalan Senior Counsel, representing the appellant, list this matter once again on Monday, date the, retaining its position, to enable Mr. Mitro to make his submission in reply.
I think, my lord, we have a
3:30. Yes.
Monday, in fact, it won't be at 10:30.
Hello?
Because at 10:30 there is swearing in of or the farewell or something.
No, that's at 3:30, sir.
3:30.
3:30. Yeah, I am never.
Farewell, sir.
Farewell full court.
3:30 full court.
Monday কত তারিখ?
27th.
ডেকে এখন কোনো লাভ নেই, ডাকবো।
ডাকবেন? Great.
Specially assigned matters. Item was 6 and 7.
My lord, appearing on behalf of the petitioners, my lord, praying for a day's time, my lord.
On the prayer made on behalf of the appellant, let these matters stand adjourned for the day.
My lord, a little prayer, my lord. My lord, can this matter be fixed in the next Friday, my lord? If the court so
Friday?
yes.
So let the matter stand adjourned for the day and be listed again on Friday date the other.
Much of it. Much obliged.
Item number 8.
Milord, I appear for the response. This is that matter where Milord section 12A, whether appealable or not. My lord was hearing it with Milord the appellate side matter when Milord Mr. Shatrup Banerjee is arguing. So Milord, somehow it has got detached. Milord, it was all along being tagged with.
Tag করে দাও।
Milord, this is the last order, but somehow it has not gone Milord tagging.
Tag
এক
করে
copy আছে একটু জজ সাহেবকে, একটা
Monday।
copy। No, it is fixed on 28 at 3:30. Milord, I have only one copy of the order.
যা আছে তাই করো আর 23:30
TPM আছে যেটা আছে along with the appellate side.
Appeal from orders. Item 9 and 10.
No, these are the ITC matters where that
Oh yes,
old stag
Yeah,
and
Bachawat.
Lake. I think Mr. Bose was.
My lord, I'm led by Mr. Learned Counsel, Mr. Tilak Bose, my lord. I'm kindly keeps it, my lord, on Monday, my lord. He's on legs, my lord.
You are for the appellant
My lord.
on Monday on the prayer made on behalf of the appellant, let these matters stand adjourned and be listed again on a Monday date দিয়ে দাও।
9 and 10. 9 and 10. 11 no. 11.
একসঙ্গে করবে 9 and 10।
Lord, I'm appearing for the appellant here.
11 Union of India.
Yes, Union Bank, I think.
Yes, Union Bank. Sorry.
Sorry.
Yes.
Yes, brief by Malot.
Who's for the respondent?
This is Malot. We were, in fact, Malot, we had started arguments for quite some time. Then Malot, it was about to be settled with regard to Malot that amount, but Malot, it did not. And then Malot, it's before Malot. It's an injunction order, Malot, which has been passed in a suit, staying Malot a sale.
Who's appearing for the respondents?
Malot, Mr. Abhijit Mitro and Malot, Mr. Vishnu Chaudhary is with me. Mr. Abhijit Mitro, Malot, was appearing Malot for the other side.
Tell us what we should do.
Malot, if it could be heard out, Malot, I would have proceeded today, but considering Malot the time and all that, Malot, I don't want to Malot trouble my lord.
Monday.
But it's a Malot order, Malot, which is on the. I would like to at least Malot say Malot suit should not be maintainable, and there can't be an order of injunction restraining sale of Malot property Malot through surfacing.
এটা লিখে নাও এই কাউকে পাঠিয়ে দাও দেখো nobody appears for the respondents in these matters. Stop. Today the court has reopened after the long vacations. Stop. Paragraph Mr. Banerjee, learned senior counsel representing the appellant, in his usual fairness says that considering that today is the reopening day, he would not like to proceed ex parte. Paragraph, let these matters be listed again on Monday, at the same position.
So sorry, my lords.
Monday.
May I only pray, my lords, if the matter may be kept a week hence, my lords, or 10 days hence, my lord. I'm being led by senior, my lord, so these are my instructions because he's not available. So no. So that's there, but then I think weekend some difficulty, my lord. We need to get ready. Kindly grant us, my lord, a
I'm
week's
going to
time.
start, so we can start on Monday. Friday I'm not there. Monday shuru kore ami tapore jodi hoy
You decide and tell us. Your junior colleague is
whatever, my lord. We are quite keen on doing the matter quite naturally, my lord. We have suffered an order of injunction. And, my lord, it was also
accommodation is prayed for on behalf of the respondents. Paragraph Mr. Banerjee, learned senior counsel appearing for the appellant bank says that the bank is suffering an order of injunction which is not tenable in law. Stop. Paragraph.
Better argument on my part.
Paragraph as requested by Mr. Bagh, learned counsel representing the respondents. Next Friday you're not there.
Next Friday.
Monday week.
Monday.
Let these matters, let these matters stand adjourned and be listed again on Monday week at the same position.
Very deeply obliged, Milord. Very deeply obliged.
Grateful.
Item 13.
Chalo, chalo.
14 and 15, Your Lordship, I appear for the appellants.
Passover, not today. Ajke ki hobe?
14 and 15.
Yes.
Item 16.
Your Lordship, I beg to appear on behalf of the appellant. Lord, this is that matter wherein the service tax, refund of the service tax with regard to the railway. Lord, that matter, my lord.
Notification.
And those notifications, my lord had asked me to
We
bring.
remember, other side is not here, sir.
I don't see Mr.
The reopening day, not today, only not today. বাবা যেগুলো both sides থাকবে না, not today করে দিও.
Item 17. Item 19.
My Lord, I'm praying for not today. Council is not there. Oh,
Yeah, that's 17. Well, at 17, my lord, fix it anytime after this matter is over. I am for the appellant.
Yes, we remember. Let it be there.
Very well.
At the same position. We take it up only after.
After I have
Yes. Not today, not today.
Item 19.
My Lord, I'm praying for not.
I appear on behalf of the petitioner.
My Lord, the council is not there. She has left the court, Lordship. Not. Gratefully, Lordship. 90.
Item 20. Item 21. Item 22 and 3.
Lordship, praying for not today.
For the respondent. Item 24. Item 25. Item 26.
Item 26, my Lord, I'm appearing for the appellant in the matter.
Sir, I'm
But
appearing for the respondent. I'm praying for not today, sir.
I only pray for a week's time in this matter. I'll get ready and I'll start arguing, my Lord. It's a heavy matter. I don't want to.
On the request made by Mr. Bagh, and advocate for the appellants. On the request made by Mr. Bagh, and advocate for the appellant. One appellant.
Lord, one appellant.
Let this matter stand adjourned for a week.
Very deeply obliged, my Lord.
For hearing, item number 27. Item number 28.
Commercial call.
হ্যাঁ হ্যাঁ ডাকতে থাকো আমাদের লিস্ট শেষ হয়ে গেলে অন্য লিস্ট ডাকো খালি ডেকেই যাও
Commercial. Item number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, and 66, 67, 68 and 69, and 70, 71 and 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, and 91, 92, 93, 94, 95, 96, 97, 98, and 99.
So 98 followed is that Jesta movement. Which one was, I don't know why it's gone down so much.
We parted is জীবনে হবে না তো এখানে কোথায় we have to fix a time I think for this
because Malad, that was fixed and then Malad was taking it up. I don't know how Malad it went down.
কবে দেবে এটা দাও but then all other council are not here. Who was arguing?
Malad, Mr. Mukherjee Malad was arguing. I am also there. Malad, he was leading me, or he is.
Mr. Mukherjee is not yet back in Calcutta.
He is Malad coming back on Monday morning, I think, not early morning. And Malad,
After
Mr.
that,
Mitro again Malad was Mr. I think Mr. Mitro's finished arguing.
Better,
Mr.
yes.
Jitu Shah was arguing.
না মঙ্গলবার তো তোমার original size হবে কি Wednesday let it be listed under the heading to be mentioned.
Very well.
Just for fixing a date and time.
Very well.
So that in the presence
because
of
that was substantially heard.
Yes.
Because it was substantially heard. I think Malad.
That is why we marked it as part heard. Normally we don't.
Correct. Correct. But it's gone down. That's why only I'm Malad
To be
interrupted
mentioned,
Malad this.
To be mentioned Wednesday.
Very great. 98 to হ্যাঁ অনেকগুলো appeal আছে yes sir.
Uh, 105, 106, 107.
হয়ে গেল তো অরিজিনাল সাইড হয়ে গেল এত লম্বা লিস্ট থাকলে না একটু সুর করে ডাকবেন না শুনতে ভালো লাগবে অ্যাপেলেট সাইড ডাকো ডেকে দাও ডেকে দাও একবার কৌশিক
After that which court Malad I shall inform.
But this is court number 1 is not second.
To say that I thought Malad I shouldn't make that Malad comment.
Appellate side, non-commercial, item number 1, 2, 3, 4, 5.
My lord, In the matter, my lord, Steel Authority of India versus Methods TLT Engineering Limited, my lord, we are appearing for the respondent, my lord, praying for days time, my lord.
Cholo, 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 cholo.
Commercial, item number 1.
কি করলে তুমি? ওরা 107টা ডাকলা তুমি?
My lord, in item number 1, appearing for respondent, my lord.
All right, thank you. Cholo.